Ordre du jour.
Report stage of Bill C-31, an act to amend the Judges Act.
Order. There being no motions at report stage, the House will proceed now without debate to the putting of the question on the motion to concur in the bill at the report stage. Mr. O'Connor, for Mr. Nicholson, seconded by Mr. Thompson, New Brunswick Southwest, moves that Bill C-31, an act to amend the Judges Act, be concurred in at the report stage. Is it the pleasure of the House to adopt the motion? Yes. Agreed? I declare the motion carried. When shall the bill be read a third time? Now. Mr. O'Connor for Mr. Nicholson, seconded by Mr. Thompson, New Brunswick Southwest, moves that Bill C-31, an act to amend the Judges Act, be now read a third time and do pass. Debate. The Honourable Minister of Veterans Affairs.
Well, thank you, Mr. Speaker. Mr. Speaker, I have the honour to rise today in support of Bill C-31, an act to amend the Judges Act. The amendment proposed in this bill would authorize the appointment of 20 new judges to the Provincial Superior Trial Courts, Mr. Speaker. And this will allow us to respond on an urgent need for more judges, to handling increasing caseloads and mounting delays in a number of jurisdictions across this country, Mr. Speaker. We've heard that in every corner of this country of ours. This amendment will support the effective and expeditious resolution of specific claims through the newly proposed Specific Claims Tribunal. Mr. Speaker, as provided in Bill C-30, the Specific Claims Tribunal Act, the members of the Specific Claims Tribunal are to be appointed among sitting Superior Court judges. And 6 of the new appointments to be authorized under the bill are intended to help the Superior Courts to free up experienced judges to take on the new work of the tribunal. The establishment of this tribunal represents the cornerstone of this government's reform of the specific claims resolution process. The remaining 14 appointments will be allocated among the 6 jurisdictions that have previously submitted compelling requests for more judges. These jurisdictions, Nunavik, Ontario, Quebec, Nova Scotia, Newfoundland, and Labrador, and my home province of New Brunswick, each one of those jurisdictions, Mr. Speaker, have provided detailed submissions to support their requests. And there is no doubt that these 6 provinces have an immediate need for these new appointments. Mr. Speaker, the Standing Committee on Justice and Human Rights gave careful consideration to this bill and has approved, without amendment, Mr. Speaker, and I think that's the key word, without amendment, and all parties in this House support this bill because we recognize that there's a real and pressing need for new judicial resources within our trial courts. Excuse me, Mr. Speaker. And so do our Chief Justices, our judges, members of the bar, and most importantly, Canadians who are involved in our judicial system. As well, Mr. Speaker, the government, First Nations communities look forward to having access to the effective and independent process offered by the Specific Claims Tribunal. And of course, we certainly do not expect that this amendment is the answer, because it isn't, Mr. Speaker, the answer to all future requirements of the courts. However, it does respond to the clear needs of the 6 affected provinces at this time. And our government, we made it very clear, Mr. Speaker, is open to considering future requests for additional judges in due course, and when, of course, that need is clearly demonstrated, as it has been in this case, Mr. Speaker. When that occurs, the government will respond appropriately. Before I close, Mr. Speaker, I want to make one final point. An important point about playing politics with our courts and the judges that preside over our courts. This week in New Brunswick, we have seen the potential harm and danger that such political games can cause. We saw the member of Beausejour, the member from Beausejour, try to score partisan points by claiming our government is not appointing enough bilingual judges.
Terrible.
Now, Mr. Speaker, even the facts show otherwise. The member from Beausejour simply refused to do his homework. Either that or he simply didn't know or purposely ignored the fact that 3 of the 6 judges that we have appointed in New Brunswick are bilingual. And of course, Mr. Speaker, that's in a province where Francophones make up 30% of our province's population. And I don't have to remind you or the House, Mr. Speaker, that New Brunswickers are proud of our place in Canada's only officially bilingual province. We are proud of our linguistic duality. We're proud of how Francophones and Anglophones work every day, Mr. Speaker, shoulder to shoulder for a better future, a stronger province, and a greater country. And our government supports that vision. We will not let the political games by the member for Beausejour divide New Brunswick or sidetrack our province from its steady progress. We're very proud of our province and progress made by all governments, past and present, Mr. Speaker, the province of New Brunswick. And in that spirit, Mr. Speaker, Bill C-31 represents an important step toward improving access to justice in Canada. I wish to thank all honourable members for their recognition of this significant advancement, Mr. Speaker, of this significant bill, and their support for steady passage, Mr. Speaker. It's very much appreciated. Thank you. Merci, Mr. Speaker.
Questions and comments? The honourable member for West Nova.
Thank you, Mr. Speaker. I would first like to thank the Minister for Veterans Affairs for his remarks. He says that he is very proud of New Brunswick, which provides judicial services in French. I know that if he represents his own province, I would like him to spread that pride as well to other provinces like Nova Scotia, where we've had a French judge replaced by an English judge, and that person has to serve the whole province. This is impossible. It is ridiculous. We have delays now and a backlog because we've reduced from 3 to 1 the number of bilingual judges. We had appointments by Mr. Chrétien that were bilingual, and now we have a new government, and we have 1 Anglophone replacing 3 Francophones, and therefore French service is not really available in Nova Scotia. And so he talks about this pride in bilingual services in the Maritimes, but he needs to help us who are Francophones and Acadians. The Honourable Minister for Veterans Affairs.
Mr. Speaker, I was speaking specifically of, and I will admit I don't know the details in Nova Scotia, Mr. Speaker, and I'm sure that the Minister of Justice or the Parliamentary Secretary would respond with more knowledge and more background than I could, Mr. Speaker. But I do know that I'm speaking when I'm speaking of what I know has happened in the province of New Brunswick, and I do know that the member supports what we have done in New Brunswick. Mr. Speaker, we've had 6 appointments. 3 are fully bilingual, 2 are Francophone. But the 3rd Anglophone, Mr. Speaker, is typical of New Brunswick, completely and fully bilingual, Mr. Speaker, something that I wish I was. And it speaks to the generosity of New Brunswick, Mr. Speaker, because as a unilingual Anglophone, when I go to northern New Brunswick, I'm received, Mr. Speaker, as I would be, I guess, in any part of Nova Scotia, any part of this country, recognizing that some of us don't have that ability to speak both languages. I wish I did, but I can't, not like the member opposite, Mr. Speaker. But it's I think, a real testament to the generosity of this country that when we go up there, Mr. Speaker, they fully appreciate that we are working on their behalf as best we can. And, Mr. Speaker, it's a real credit to this country and my home province in New Brunswick that a unilingual Francophone or Anglophone can be successful, can achieve high office in government and in our court system. But we are very sensitive, Mr. Speaker, about when people are going before the courts that we have that bilingual capability within our court system, Mr. Speaker. We work very hard to achieve that. And one of the things I want to point out to the member opposite, Mr. Speaker, that the member from Beausejour was being disingenuous when he spoke, because, Mr. Speaker, one point that I made when I responded to the newspaper, the Telegraph Journal in Brunswick, when they ran what I considered to be a very one-sided story that didn't actually represent the facts. Mr. Speaker, one of the things that we did in New Brunswick, one of the judges that we appointed to what we call the Military Judges Compensation Committee was, in fact, the father-in-law of the member from Beausejour. And the reason that he was appointed is because he's very qualified, Mr. Speaker. His name is Guy A. Richard. In fact, the father-in-law of the member from Beausejour that was standing up suggesting that we didn't honor bilingualism in the province of New Brunswick. I mean, that's totally disingenuous, Mr. Speaker. So in addition to the judges that I'd mentioned to the Superior Court, we appointed his own father-in-law. So Dominic LeBlanc should be considerate of that, Mr. Speaker, and be very cognizant of that when he's on his feet in the House of Commons. We appointed his own father-in-law. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Western Arctic.
Well, thank you, Mr. Speaker. And sometimes the nomenclature Western Arctic confuses me as well. It should really be Northwest Territories if we can ever get some name changes for our ridings. But, Mr. Speaker, to the question, you know, in the Northwest Territories, of course, we have a very high rate of criminal charges, and the judges are very important to us, of course, and we appreciate you know, the work that they do. However, you know, our government right now is under severe cost reductions. They're engaged in a cost reduction program. With this plan by the Conservative governments that will salary the judges, but in the Northwest Territories where we have to fly judges with their court staff to locations that are thousands of miles away from their courthouse sometimes, how is this going to ensure that we have the kind of resources required to take on these extra judges?
The Honourable Minister of Veterans Affairs.
Well, Mr. Speaker, we've responded, I think, in a very positive way to a need across the country, but I'm not sure that the member's constituents would be real pleased to hear that he's suggesting there's a high rate of crime in his area, Mr. Speaker. But, Mr. Speaker, I think again, this bill is supported. I think and it very seldom happens in this place, as you well know, Mr. Speaker, but there's almost complete agreement on what the Government of Canada is doing, because we are responding to a need, a real need, Mr. Speaker. So I'm very proud of what we're doing, and I think just the agreement that you see in this House, Mr. Speaker, clearly indicates that that Parliament does support exactly what the Minister is doing, and I'm very pleased to have been able to respond this morning to that, Mr. Speaker. Thank you.
The Honourable Member for Wetaskiwin.
Well, thank you, Mr. Speaker. And first of all, I'd like to thank the Minister of Justice for bringing this bill forward, and of course I'd like to thank my colleague, the Minister of Veterans Affairs, for speaking to it today. I'm a member of the Justice Committee, and I remember discussing this bill briefly at the Justice Committee. And my question for the Minister has to do with the appointment, the increase in the amount of Superior Court judges from, I believe, 30 to a pool of 50 judges. And of course, Mr. Speaker, in my riding there are First Nations reserves, and across Canada there are First Nations reserves. We have a huge backlog of land claims that need to be worked through, and I was just wondering if the Minister could provide this House with some more information or some more discussion in regards to how the appointment of these judges in regards to the land claims tribunals will improve the efficiency of the tribunal process, improve the efficiency of land claims, and basically provide good value to Canadian taxpayers in moving that file forward.
The Honourable Minister of Veterans Affairs.
Well, thank you, Mr. Speaker. I want to thank the member from Wetaskiwin for the hard work that he's done on the Justice Committee, and as one of those that was privileged to visit his riding, Mr. Speaker, beautiful riding that he represents. But, Mr. Speaker, more specifically to his point, I do know the lands claim issue is a big one, Mr. Speaker. Again, a Minister of Indian and Northern Affairs could speak with more authority than I could, but this is in a direct response to some of those needs up there to free up the court to proceed with some of this, Mr. Speaker. And I think the member is being much too modest himself, Mr. Speaker, in addition to being honest, but much too modest in terms of his contribution to the Justice Committee and the very positive role that he's played in bringing this legislation forward. So I think all members should applaud his hard work, and I'm quite convinced, Mr. Speaker, that the bill that we have will reflect the real need in some of the specific areas that he mentioned, Mr. Speaker. Thank you.
Resuming debate, the honourable member for London West.
Thank you, Mr. Speaker. I'm happy to speak to Bill C-31. It has now been through the Justice Committee and has returned to this House unamended. This is a very short bill, but the bill does amend a number change in the Judges Act, paragraph 24, 3B, and thus creates the authority to authorize the appointment of 20 new judges for the provincial and territorial superior trial courts. We know, Mr. Speaker, that these judges are needed to deal with the increasing backlogs in the Superior Court system, and in particular, Superior Courts in Ontario, Quebec, Newfoundland and Labrador, Nova Scotia, New Brunswick, and Nunavut continue to experience delays and backlogs. And, Mr. Speaker, in a former parliamentary life, when the Liberal government was here, I was a parliamentary secretary to the then Minister of Justice. And I traveled through Nunavut and experienced the fact that, unlike the rest of Canada, where you can go by vehicle from one city to another, these are fly-in communities, 26 different fly-in communities, and it takes time, and there are delays that needed to be attended to. I remember at that time we also were starting to introduce our crime prevention programs, and that is the other end of the justice system, from the trial and the judgment end right to preventing crime. And I think there needs to be a full emphasis in this aspect, and it does help reduce criminal activity when people are actively engaged in different crime prevention activities. And I did want to make that point at this point in time, Mr. Speaker. Even in the other provinces in Canada, those that I didn't mention, we are aware that there is a strain with simply population growth, and especially there are stresses that could happen with the family court systems. And in a family court system, you just can't afford time delays because children grow up and those issues have to be resolved sooner rather than later. We also have the issues of mega trials in the criminal law area. As you know, Mr. Speaker, a lot of the criminal law is taken care of at the provincial court level, but there are those mega trials, and people can opt to go into the higher court level. But the mega trials are very complex, very lengthy, and consume a lot of justice system resources. But I know this is important to all Canadians. This bill, in the introduction and the background for this bill, we're talking about the fact that we now have a specific claims tribunal which will have the authority to make binding decisions where specific claims brought forward by First Nations are rejected for negotiation or where negotiations fail. And it is estimated, Mr. Speaker, by the government that this tribunal will require the equivalent of 6 full-time judges to manage the caseloads of these types of claims. And the Chief Justices, I'm sure, will have consultations with the Minister or his designates to talk about the allocation of these judges. And I know that BC and Ontario will need these resources, as well as some of the other jurisdictions, because specific claims should be settled, Mr. Speaker. It is important to have access to justice for all Canadians, and it is true that justice delayed can be justice denied. In criminal law, the Askoff case reminded us, I think, very bluntly, that the importance of reasonable time limits and reasonable access to the court system. We don't want to have cases thrown out of court just because there's been lengthy delays, too lengthy delays. And apart from the judges needed for the tribunal work, these judges, Mr. Speaker, will work in the area of civil law, civil litigation, family law, and criminal fields of law. They are expected to perform all of their work for us with the independence and impartiality that I think Canadians expect from their justice system. The judges apply the law to the facts of each case. They do so without imposing any of their own personal bias. Increasingly, as I've said, cases are complex and trials can become very lengthy. Delay is not wanted by the Canadians in this country. Canadians want to have justice delivered in their own language, be it English or French, and reflect the linguistics. Mr. Speaker, I'm having a problem even hearing myself with the chatter in the House. Thank you, Mr. Speaker. As I was saying, that Canadians want to have justice delivered in their own language, be it English or French, and this does reflect the linguistic duality of our country, and I think it is important, and is not a political or partisan point, to make the point that both French-speaking and English-speaking justices are needed in our court. And in fact, there is often interpretation provided for other languages because there are people before the Canadian justice system that speak neither of these languages, but that is not the point with respect to the appointment of judges. I myself have great respect for our judicial system in this country. I think we have an amazingly fair and independent system. I don't want to see that change in any way. I have respect for the judges that do their work. These people are somewhat limited in their association with the rest of Canadian society. There's an expected distancing so they can contain that impartiality and do their work properly. I would say that these increases for the number of judges have been needed for some time, and we expected this bill sooner. I'd like it to go forward. As of yesterday, though, I'd like to point out to this House that March 13th, 2008, even without this bill, there were 25 judicial vacancies waiting to be filled that the Minister of Justice and Attorney General for Canada is responsible for filling. So in other words, there are already more than the vacancies that this increase will give us, existing vacancies that have to be filled. This is an ongoing situation, and I know that we should be encouraging the filling of all positions because it's important for our system to work efficiently and properly. And as many in this House will recall, this new Conservative government stacked the Judicial Advisory Council to ensure that the Justice Minister's chosen representatives have a majority on every provincial judicial advisory board. I'm not going to go too much into this at this time because I think it does take away from the most important discussion and the subject matter of this bill, but I do note it. It is important to keep the judicial independence in this country. I remember the Chief Justice of the Supreme Court making comment on this point, and also it's important that the positions be filled and not have great delay. Both of those points are important. With respect to this short bill, though, we can in this House agree that it should move forward. I know my colleagues in our party want the smooth functioning of the justice system, and this is one, but only one aspect that can be assisted by this House. We must remember that there will not be a smooth functioning if there are not enough prosecutors, if there's not sufficient dollars for legal aid for people who need that assistance before the courts. We need all of the system to work cohesively, and the judges is one part of it, but it is the full functioning of the court system that has to be brought to bear before justice is actually delivered to Canadians in a timely manner and an effective manner. So I ask, Mr. Speaker, the fellow members of this House to support this legislation so that it can rapidly move to the other House, become law, and do so after their deliberations in the other House. But I think this is one bill that this House can believe will be good for the country, be good for the citizens, and we need the expertise and the impartial judicial system in this country that we all deserve. Thank you very much, Mr. Speaker.
Questions and comments? The L'Honorable Député.
The Honourable Member for Hochelaga. Happy Friday and happy Easter to you and your family, Mr. Speaker. First of all, I would like to say to my colleague for London, and I have happy memories of working with her when we were both on the Justice Committee. We know that the government doesn't always have a positive track record with respect to its relationship with the judiciary, because police officers are now going to be sitting on the selection committee, and that will have a negative impact on the selection process. But that's not what my question's all about. I believe that the member has legal training, and I would imagine that she is aware of a decree that was issued in Northern Ontario, ESCOF,
And in the ESCOV decree, well, it almost invalidated almost 10 trials that were going on in Ontario because it was said that justice wasn't performed diligently and it wasn't compatible with the charter provisions that said that you were entitled to have a fair and equitable trial. Today, we have a remedy with the 20 judges being appointed now, but I would like the member to give us her comments on the ESCOV decree and on the need to have a diligent judiciary system. And I'd also like her to give her comments on the Justice Committee chair who refuses to hold meetings because he doesn't want any light to be shed on the ethical issues of the Cadman affair. The Honourable Member for London West.
Mr. Speaker, and for many years I sat with this colleague in the Justice Committee, and I found that he worked on the criminal law aspects and the bills quite diligently, and we worked well together in that committee. He's also correct. I did practice law for 15 years. I did some teaching of law at both the bar ads and the university part-time continuing education level. And I think that some of us with that training do understand an important decision like ESCOV. ESCOV was a decision that impacted the criminal courts, and in my province of Ontario, some people who were charged were let go without the continuation of those charges. Why? Because delay. When you have fairness in a justice system, you have to have timely hearings. That just means that you cannot keep putting off court dates. Witnesses disappear. They forget. We have to have that court system to be in a timely fashion so that the court functions at its optimal. And in those cases, it had a great impact. It put a real chill. It took us back because people were let go that didn't have their trials completed because the system wasn't providing the systemic fairness that comes with the timely work. And that is very important. Now, that criminal law case applies now everywhere in the criminal justice system. There is no case that's saying that in a family law or a civil litigation, but the principles are there. The principles are that, both sides get procedural fairness. So timeliness is one very important aspect, Mr. Speaker. I will also comment, when I was in the Justice Committee, we always had our meetings. In fact, we had very many meetings. Back in 1995, I can remember that we were meeting all the time with some pieces of legislation, sometimes till late in the night. And now I believe there's 2 or 3 committee meetings where the chair has refused to do his duty as the procedural chair of the committee and sit and take the votes, and has left the committee, leaving, I think, 2 vice chairs. But this changes the numbers. It changes the numbers for voting systems. And so this was we know, Mr. Speaker, in this House that there's been a procedural manual given to members of the government that tells committee chairs how to operate, how to delay, how to get favorable witnesses. In my time, I've chaired, Mr. Speaker, the Finance Committee, for example, 3 times in former parliaments. I made sure that the system was fair to all. I made sure that everybody could bring the witnesses they want, that both sides of the argument was there. And in fact, the chair's job was not to do a partisan job, but to ensure that the procedural rules are followed. And I think that most of us can do that in this House, and I'm surprised at what's happening in the Justice Committee, because this is a committee that needs to work. This is a committee that has a high volume of legislation, and I know that members sitting opposite have been with me, even where we did hard work in this committee. We may disagree on our points of view and the way we want something to come out of the committee, but I also know that there has been a very strong history of everybody working hard in this committee, and I think it's a shame that it's not continuing.
Questions et commentaires.
Questions and comments?
Resuming debate. La reprise de débat.
Resuming debate. The Honourable Member for HoC. Thank you, Mr. Speaker. I'm pleased to share the position of my party with respect to this bill. C-31 which is a bill, Mr. Speaker, which in appearances may look quite technical, and it has an impact on the way the judiciary operates. Bill C-31 is a bill that everyone is looking forward to. I think there are 2 sections in the bill, and it will enable the federal government to appoint judges to the additional judges to the Superior Court. Right now, there are 30 justices that can be appointed by the federal government, and there is a backlog in the system. When we have proceedings, well, the time between the proceedings and the time when the decision is rendered by judge or judge and jury, sometimes a year and a half can have elapsed, sometimes 3 years. I'm not talking about the Supreme Court here. I'm talking about the superior courts that deal with criminal code. We're not dealing with technical matters, such as those matters that would be dealt with by an appeal court, or we're not dealing with issues that are going to have to be dealt with by the Supreme Court. We're not looking at the validity of the legislation per se. We're dealing with everyday cases that should be dealt with as quickly as possible. So the bill, Mr. Speaker, C-31, suggests that 20 additional judges be appointed, which would mean that there will be 15 judges appointed to various superior courts. I'd like to take a few moments, if I'm able, to attract the attention of my colleagues in this House to the fact that we must not confound trial courts with superior courts in Quebec. As you know, Mr. Speaker, Quebec will one day be a sovereign nation with all that entails. Sovereignty means 3 things: keeping all tax money, repatriating all powers. That means, of course, deciding on our foreign policy. Yesterday, I checked with our research office. You know, Mr. Speaker, that for the year 2008, Quebecers are going to send $50 billion in taxes to Ottawa. So just imagine the difference this would make if Quebec, if its a National Assembly, were able to keep this tax money. Obviously, we would do things differently. And further to the information provided by the research office, which, by the way, is a very good department. Well, look, can you imagine? Just look at the national defense budget. It's going to go up to $19 billion. So we're going to double the military budget. And a lot of this money is going to the purchase of equipment. But in a sovereign Quebec, do you think we would have made such a choice? I think that my colleagues will agree that if we had a sovereign Quebec, we would be putting much more emphasis on international cooperation, on development. We would be help Africa, Francophone Africa. We would be much more visible in Haiti. We would really develop cooperation projects there. So, Mr. Speaker, with a sovereign Quebec, we would have all of the attributes that we would require, but that's not the case right now, and that's why, for the television viewers, must understand that Quebec and its National Assembly, well, the Minister of Justice is the one who appoints judges to municipal courts and the Quebec Court. The Quebec Court has 2 chambers, the civil chamber and a chamber which is a courthouse for young people. And that leads me, Mr. Speaker, to lament the fact that soon we will be examining, but we will not accept this, I was saying to at the steering committee, at the Justice Committee, that things have really changed in the committee, where people could get information from each other. We took care of each other, but you know, Mr. Speaker, that the climate has degenerated at the Justice Committee. We are now dealing with a chairman who refuses to assume his responsibilities. He is not chairing the committee. And why is it that we've got to this point of non-return? We feel that the attitudes are degenerating. We don't know if we can go back to the ambiance that we once had, Mr. Speaker. But I must tell you that the Justice Committee is not meeting because the member for Beauséjour tabled a motion inviting the Justice Committee to look into the allegations with respect to the Cabinet affair based on Section 119 of the Criminal Code. And that's the responsibility of the Justice Committee. Is it not the duty, and I would ask this question to all my colleagues, is it not our incumbent on us to ensure that under every circumstance the institutions which give life to us parliamentarians are above reproach? But as soon as we read in the media, as soon as we read in a book that there are allegations of corruption, perhaps they may not have any basis, but, Mr. Speaker, it's the role of the Justice Committee, and other committees could have examined this issue, but for reasons that I don't want to go into, I can understand that the Ethics Committee doesn't want to look into this.
Now, Mr. Speaker, the Justice Committee, through the member for Beauséjour, a gentleman who's respectable and has great self-control, who's done his work as a parliamentarian by tabling this motion, which was, of course, supported by the Bloc. When the chairman decided that the motion was out of order, as the standing orders of the House of Commons allows us, we challenged the chairman's decision, and the chairman refused to call a vote for that motion to be challenged. And he left the chair, leaving a terrible void that prevented us from functioning. Now, having said that, I don't want to go off on a tangent. Let's get back to Bill C-31. The National Assembly appoints judges for municipal courts and Quebec Court. It's divided into two, civil and the youth criminal court. I was very disappointed to see that we're going to be seized with Bill C-25, which is a very bad bill, Mr. Speaker. A terrible bill because C-25 deals with the youth criminal justice system. The 5-year review was to take place, but before that, the government wants to amend 2 clauses. We, in the Bloc Québécois, the honourable member for Hochelaga has indicated that there's a problem here. He is not discussing the bill before the House. He's discussing... We are discussing the Judges Act. Perhaps he could discuss the subject of today's debate at third reading, rather than having a discussion about other bills introduced by the government regarding the Department of Justice. Well, Mr. Speaker, I'm surprised by your remarks because Bill C-31 concerns justice, it concerns judges, and I think there are links with other bills. I know that you will allow me to establish those links. In Bill C-31, with which we are seized now, there is mention of appointing judges. We are in favor of this bill, but we are very disappointed that the government didn't wait for the bill, or rather the criminal justice system was not the subject of a complete review before a bill dealing with two provisions of that system was tabled. You were a speaker, I believe, when the member for Berthier-Montcalm, the former member for Berthier-Montcalm, one of the best members we ever had in this House, who tabled 2,700 amendments to the criminal justice bill. It gave rise to a decision whereby you tightened the criteria about amendments. I'm not criticizing that ruling, but let's get back to C-31. I'd like to discuss the HoC case. As you know, there are constitutional guarantees in the Charter of Rights and Freedoms. Of course, the Canadian Charter of Rights and Freedoms is not a legal tool that was desired by the National Assembly of Quebec. You will recall that almost unanimously in 1982, the National Assembly had adopted a motion to oppose the unilateral patriation of the Constitution under the Liberals of Pierre Elliott Trudeau, who had defied the will of the National Assembly. Even the leader of the official opposition in the National Assembly, Claude Ryan, agreed with René Lévesque at the time. Now, having said that, the Constitution, as patriated despite the wishes of the National Assembly, includes a charter which provides legal guarantees, major, broad guarantees that we all know. There can be no there's a protection for the freedom of religion, freedom of assembly, free speech. It says that trials have to be fair and equitable. It addresses evidence and how it's collected. There is Article 24, which talks about disregarding evidence when it's collected in a non-constitutional way. Now, among the constitutional guarantees in the Canadian Charter of Rights, patriated despite Quebec's wishes, there is the of having a fair and equitable trial. When you're talking about a fair trial, well, of course, you take into account the length of the trial, and it's understood that once proceedings start and lawyers get involved and a judge, a jury render a decision, if 2.5, 3 years go on, that violates the constitutional guarantee. Now, the reason why the Bloc Québécois supports this bill is because they seek to appoint 20 new judges, which will break this bottleneck in the justice system and ensure that justice is rendered more promptly, with greater celerity and diligence. Now, Mr. Speaker, those 20 judges, of course, we don't yet know in detail how many there will be for Quebec and for Ontario and so forth, or Newfoundland for that matter, but I must inform the House right away, and I'm doing so on behalf of our colleague from Abitibi, who's a friend of Aboriginals, who is a jurist himself. He's a vigorous trial lawyer who always struck a balance between the defense for the accused in the system and the obligation the Crown has to sentence and convict people when the situation warrants. Now, the member for Abitibi did me the great honor of coming to the Justice Committee at a time when it met and the government accepted that we had a lot of work to do. But that time has passed, as you know, since the Conservative chairman refuses to call the Justice Committee. This is like, I'm in mourning, really, because I love my work. I love to be in committee, especially the Justice Committee, but I have to be given the opportunity to do so, and it hasn't been given to me in the last 3 scheduled sittings. Now, the member for Abitibi made representations. He gave me the pleasure of accompanying me to the Justice Committee to discuss Aboriginal law and Aboriginal rights. When I was a student at the University of Ottawa in law, I took a course on Aboriginal law, and I realized the richness of that type of law. Now, you probably know that there's a good chance that a judge who currently sits on the Ontario Court of Appeals could be appointed to the new Truth and Reconciliation Commission, which means that the Ontario Appeals Court may be deprived of a judge, Mr. Speaker. And we expect that the government, the federal government, will take into account in the attribution of new resources under C31. We expect that this appointment from the Ontario Court of Appeals to the Truth and Reconciliation Tribunal, and thanks to the vigilance of the member for Abitibi, who is a friend of Aboriginals, as I repeat, you will recall that this is the member who put a question in the House when the Conservative government refused to enshrine the Declaration on the Rights of Indigenous Peoples at the UN. That brought us 20 years backward, whereas all opposition party, the Bloc, the NDP, and the Liberals, wanted ratification of that instrument, but only the Conservatives, this archaic, backwards government, refused to ratify that convention. So thanks to the kindness of the member for Abitibi, we were made aware of this tool that is wanted by the Aboriginal nations. And we are aware that when the Truth and Reconciliation Commission is created, it will shed historic light on the suffering and injustice of the Aboriginal peoples, a founding people, something the government of René Lévesque recognized in 1985 when Mr. Lévesque was Premier. The National Assembly recognized 11 nations. Jacques Parizeau distributed our referendum project door to door. We all recall that there was a recognition of the Aboriginals, as there was a recognition of the historic contribution of Anglo-Quebecers. Now, all this to say, I don't want to be out of order, but I want everyone to know that we support Bill C-31. We've worked very hard in committee for the bill to be delivered to the government as quickly as possible. It's quite a short bill, and once again, I think it will enable us to administer justice much more diligently. We all know the Askov decision, whereby the Ontario Court of Appeal stated or released certain people who'd been in charge because they could not get a trial within a reasonable time frame. It created quite a commotion in justice circles, and since then, pressure has been exerted on various governments to ensure that there are more judges in different appeal courts. Year after year, there are more and more trials. Often they are more complex trials. There are dilatory tactics to delay proceedings. We know how this all goes on in court, and I think we must salute the fact that there will be 20 additional judges, as I said earlier. We don't know how many there will be for Quebec. We hope there will be at least 3 more, but Mr. Speaker, we'll wait confirmation of that. So I repeat, this is a bill that receives Bloc support, and I'd be pleased to answer questions from colleagues, and I hope to have another opportunity to sit on the Justice Committee like in the good old days.
Le débat recommence.
When the debate resumes, the member will have 10 minutes for questions and comments.
Prepared to rule on the point of order raised by the honourable member for Mississauga South on March 3, 2008 concerning the proceedings in the Standing Committee on Access to Information, Privacy and Ethics at its meeting of February 28, 2008. I'd like to thank the honourable member for Mississauga South for having raised this matter, as well as the honourable parliamentary secretary to the Government House Leader, the honourable member for Hull-Aylmer, and the honourable member for Scarborough Rouge River for their contributions.
In raising his point of order, the member for Mississauga South expressed concerns about motions adopted by the Access to Information, Privacy and Ethics Committee at its meeting of February 28, 2008. Of particular concern was the motion ordering the committee, pursuant to Standing Order 108-1A, to investigate the fundraising practices of the Liberal Party of Canada. The member for Mississauga South indicated that as chair of the committee, he had ruled this motion inadmissible as it did not include any reference to the Conflict of Interest Code for members or any ethical standards that may have been violated, but rather actually made direct reference to potential violations of the Canada Elections Act. His ruling was appealed and overturned, and the motion was adopted.
The member for Mississauga South contended that the Access to Information, Privacy and Ethics Committee has now embarked on a study which is beyond its mandate as set out in Standing Order 108. Questioning the committee's authority to disregard the standing orders in this way, he maintained that his committee was encroaching on the mandate of the Standing Committee on Procedure and House Affairs. The member for Hull-Aylmer and the member for Scarborough-Rouge River voiced their support for these arguments. In his comments, the Parliamentary Secretary to the Government House Leader and Minister for Democratic Reform spoke of the well-recognized procedural principle that committees are masters of their own proceedings. In the absence of a report from the committee, he suggested that it would be inappropriate for the Speaker to pass judgment on the question raised by the member for Mississauga South and cautioned against prejudging the direction that the committee's study might take. After careful review of all the interventions on this point of order, it seems to be that the crux of the matter is determining first to whom the House has given a mandate in matters relating to ethics, and secondly, what differentiates one mandate from another. L'alinéa 108.
Standing Order 108-3H states that the Standing Committee on Access to Information, Privacy and Ethics has responsibility for overseeing the effectiveness, management and operation, together with the operational and expenditure plans of the Conflict of Interest and Ethics Commissioner, as well as the Commissioner's annual reports on activities in relation to public office holders. It is important to note that reports on complaints involving public office holders are provided for in the Parliament of Canada Act and are filed with the Prime Minister with no provisions to have them referred to a committee.
Mandate is not to be confused with that of the Office of the Conflict of Interest and Ethics Commissioner, whose remit is twofold. First, to support the House of Commons in governing the conduct of its members by administering the Conflict of Interest Code for members of the House of Commons, which has been in effect since 2004, and second, to administer the Conflict of Interest Act for public office holders, which came into effect on July 9, 2007. Oversight of the Conflict of Interest and Ethics Commissioner's work related to members under the Parliament of Canada Act and with respect to the Conflict of Interest Code for members is the responsibilities of the Standing Committee on Procedure and House Affairs. This is clearly indicated in Standing Order 108-3A, 7 and 8. The Procedure and House Affairs Committee is also responsible for matters relating to the election of members as set out in subparagraph 6 of Standing Order 108-3A. Comme le soulignait le vice-président,
as was pointed out in a ruling given by the then Deputy Speaker on June 3, 2003, at page 6775 of the debates, concerning alleged irregularities in the proceedings of the Standing Committee on Transport, and I quote, "I have said that committees are granted much liberty by the House, but along with the right to conduct their proceedings in a way that facilitates their deliberations, committees have a concomitant responsibility to see that the necessary rules and procedures are followed," unquote. Similarly, House of Commons Procedure and Practice, page 879, explains that, quote, "Committees are entitled to report to the House only with respect to matters within their mandate. When reporting to the House, committees must indicate the authority under which the study was done, i.e. the standing order or the order of reference. If the committee's report has exceeded or has been outside its order of reference, the Speaker has judged such a report or the offending section to be out of order," unquote.
Two particularly illustrative examples are included in the footnote to this citation. The first involves a report by the then Standing Committee on Finance, Trade and Economic Affairs regarding the radio and television broadcasting of all committee proceedings, which Mr. Speaker Bosley, in a ruling given on December 14, 1984, debates, page 1243, ruled out of order on the grounds that the committee had exceeded its order of reference. The second relates to a report presented by the then Standing Committee on Labour, Manpower and Immigration, which likewise was ruled inadmissible by Mr. Speaker Bosley in the debates on February the 28th, 1985, at page 2603, again because the committee had exceeded its terms of reference. Even this brief overview serves to remind us all that the House has taken great care to define and differentiate the responsibilities of its committees, particularly where there might at first glance appear to be overlapping jurisdictions. That said, it is also clear that the House has chosen to allow committees great flexibility and considerable powers, including the power to use their own initiative by undertaking studies within their mandates. Inherent in the power of the House, in the power the House grants to its committees is the basic principle that each committee will respect its mandate. Implicit in the flexibilities that committees have traditionally enjoyed is the understanding that they will be judicious in the exercise of their powers. Can it be said that the Ethics Committee, measured against these standards, is acting appropriately in this instance? Frankly, I find it hard to answer that question for a number of reasons.
First, as the Honourable Parliamentary Secretary to the Government House Leader has reminded the Chair, successive speakers have been reluctant to intervene in the proceedings of committees except in highly exceptional circumstances. The Honourable Parliamentary Secretary goes on to caution against presuming on the direction that the committee's study might take and jumping to conclusions about the nature of any report it might present.
Acknowledge the validity of that argument. The Chair is not in a position to determine what interpretation the committee will give to the motions that gave rise to the point of order raised by the honourable member for Mississauga South. However, I do wish to make clear to the House that the question of committees respecting their mandates is not one which the House should take lightly. For
the present, I cannot find sufficient grounds to usurp the role of committee members in regulating the affairs of the Standing Committee on Access to Information, Privacy and Ethics. However, if and when the committee presents a report, should members continue to have concerns about the work of the committee, they will have an opportunity to raise them in the House, and I will revisit the question at that time.
Cependant,
but if the House will bear with me, I said earlier that I was not comfortable deciding on whether or not what the Ethics Committee had done was appropriate. I'd like to return to that statement, and I ask for members' indulgence in hearing me out.
Any observer of the 39th Parliament will realize that the problem of the Ethics Committee is only one of the recent manifestations of the need for crisis management in committees.
Almost a year ago, in a ruling given on March 29, 2007, I referred to the challenges encountered in this minority parliament, saying in part, neither the political realities of the moment nor the sheer force of numbers should force us to set aside the values inherent in the parliamentary conventions and procedures by which we govern our deliberations, unquote. I went on to refer to situations in committee where, because decisions of the chair are subject to appeal, decisions that were procedurally sound had been overturned by the majority.
Appeals of decisions by chairs appear to have proliferated, with the result that, having decided to ignore our usual procedure and practices, committees have found themselves in situations that verge on anarchy. Even the prestigious Standing Committee on Procedure and House Affairs, which, as the striking committee is the very heartbeat of the committee system, has not escaped the general lawlessness. Last week, I understand that the committee elected as its chair a member who stated unequivocally that he did not want the nomination. What responsibility does the Speaker bear for quelling this anarchy that appears to be serially affecting committees in recent weeks? I would refer honourable members to a comment of Mr. Speaker Lamoureux on July 24, 1969, when he said, "What honourable members would like the chair to do is to substitute his judgment for the judgment of certain honourable members. Can I do this in accordance with the traditions of Canada, where the Speaker is not the master of the House? The Speaker is a servant of the House. Honourable members may want me to be the master of the House today, but tomorrow, when perhaps in other circumstances I might claim this privilege, they might have a different opinion. It would make me a hero, I suppose, if I were to adopt the attitude that I could judge political situations such as this and substitute my judgment for that of certain honourable members. But I do not believe that this is the role of a Speaker under our system." End of quote.
The rules that govern our deliberations and the practices that have evolved over time generally serve the House and its committees very well. As your Speaker, I will sometimes suggest that members take their grievances to the Standing Committee on Procedure and House Affairs and ask them to look at whether changes to our standing orders might alleviate such difficulties in the future. But that would not be a helpful suggestion in the present circumstances.
Members know as well as I do, or even better than I do, since they are living with the consequences daily, that it is not by tinkering with the rules that we will solve our current difficulties. Nor do I believe, whatever certain media commentators may say, that our difficulties would be resolved if only I, as your Speaker, agreed to act in loco parentis and scolded honourable members into seeing reason. Frankly speaking, I do not think it is overly dramatic to say that many of our committees are suffering from a dysfunctional virus that, if allowed to propagate unchecked, risks preventing members from fulfilling the mandate given to them by their constituents. To quote House of Commons Procedure and Practice at page 210, "It remains true that parliamentary procedure is intended to ensure that there is a balance between the government's need to get its business through the House and the opposition's responsibility to debate that business without completely immobilizing the proceedings of the House." Fin de citation.
Unquote. The Speaker must remain ever mindful of the first principles of our parliamentary tradition, which Bourrineau described thus, quote, "To protect the minority and restrain the improvidence and tyranny of the majority, to secure the transaction of public business in a decent and orderly manner," unquote.
Not that the minority in the 39th Parliament happens to be the government, not the opposition, or that the majority is held by the combined opposition parties, not the government. The Shakespearean quote, "The fault is not in our stars but in ourselves," seems sadly apt in the circumstances. Like all Canadians, and indeed all honourable members, I realise and respect that political exigencies often dictate the strategies adopted by parties in the House. However, as your Speaker, I appeal to those to whom the management of the business of the Parliament has been entrusted, the House leaders and the whips of all parties, to take leadership on this matter, and I ask that they address themselves to the crisis in the committee system that is teetering dangerously close to the precipice at the moment. I ask them to work together to find a balance that will allow the parties to pursue their political objectives and will permit all members to carry on their work. I'm confident that working together in good faith, they can come to an agreement that will return us to the equilibrium that our procedures and practices have been designed to protect. And as your Speaker, I stand ready to lend whatever assistance I can. I would like to thank the honourable member for Mississauga South for having raised the matters relating to the Standing Committee he chairs and the opportunity to address the larger picture. Je remercie.
I thank the House for its attention.
Statements by members. Déclaration des députés. The honourable member for Edmonton-Sherwood Park.
Thank you. The public debate on my private member's bill, C-484, is going very well. When people hear and understand the true purpose of my bill and are assured that it is targeted totally and directly to the pregnant woman who has chosen to give birth to her child, they agree that this legislation is urgently needed. This bill protects women because you can't get to the child without attacking the mother. Studies show that pregnant women are much more vulnerable to attack, and the attacks are more vicious. My bill protects them. A woman should not be left to stand alone in defense of her life and the life of her child. 72% of Canadians support this legislation. 75% of women support it. 79% of youth support it. Support crosses political lines, with the lowest level being at 66% for those who identify that they vote for the NDP. Every group has a majority of people in support of this legislation. When a willing mother is having a wanted child, no one has the right to take that choice and the child that she wants away from her. Thank you, Mr. Speaker.
The Honourable Member for Laval-Les-Îles. Mr. Speaker, it being the Quebec Intellectual Disabilities Week, I would like to pay particular tribute to Madame Chantal Gay, who is from Laval, a wonderful woman who unfortunately died in December at the age of 51. For 8 years, she headed up the Laval Association for Intellectual Disabilities. She gave generously of her time with great love and respect for those she served, and she was very attached to them. She sat for a number of years on the board of directors, on the Promotional Association for People with Disabilities in Laval, and initiated the Hats Off project that honored 5 people every year in Laval with intellectual disabilities. She was very committed and certainly deserves this tribute we are paying to her today on behalf of those of Laval. The Honourable Member for Bois-Salaberry. Mr. Speaker, on behalf of all my colleagues in the Bloc Québécois and my own name, I would like to congratulate the 24 firefighters from Salaberry de Bellafield, Beauharnois, Sainte-Martine, Saint-Étienne de Beauharnois, and Saint-Louis de Gonzague, who have received a medal or a ribbon for distinguished service. They were given these honors by their municipalities. They are all firefighters, chiefs, captains, lieutenants, assistants, or directors of a firefighting service. These men and women work with perseverance in a dangerous occupation to save lives, and they always risk their own. The unfortunate events of the past weeks confirm the dangerousness of their occupation. I want to congratulate them. I admire all of them.
Honourable Member for Western Arctic.
Mr. Speaker, this week more than 2,200 athletes, coaches, and officials from the northern regions of Canada, Russia, Greenland, Norway, Finland, and the United States have gathered in Yellowknife, Northwest Territories, for the 20th Arctic Winter Games. This is a very special event for the people of my riding. Yellowknife hosted the very first Arctic Winter Games back in 1968. The Games focus on traditional sports such as soccer, hockey, skiing, and gymnastics, along with unique Arctic sports, but also places emphasis on the diversity of northern cultures. This is reflected in the year's theme, a celebration of sport and culture. Tomorrow I'll be presenting bronze, silver, and gold Ulu medals to athletes and celebrating another successful Games with thousands of participants at the official closing ceremony. I would like to extend my congratulations and sincere thanks to all who have helped to make this 20th Arctic Winter Games the best ever, especially the dedicated volunteers who have worked so hard to make it all happen. Thank you to Yellowknife, Northwest Territories.
The Honourable Member for Saskatoon-Wanuskewin.
Mr. Speaker, yesterday morning the body of Mar Palash Faraj Raho, the Chaldean Catholic Archbishop of Mosul, was found riddled with bullets in northern Iraq. He was kidnapped in late February as he left church. The death of Archbishop Raho is a tragedy that illustrates the difficulties faced by Iraq's Christian population. The gruesome murder is just one example of the tragic persecution faced by Iraqi Christians, and I would like to take this opportunity to draw the House's attention to the community's struggles. Iraq's Christian population is dwindling in size because of this new wave of violence leveled against them. This community constitutes only a small fraction of Iraq's predominantly Muslim population. They are one of the oldest communities in Iraq, being distinguishable by their Christian religion, unique culture, and Aramaic language, which was spoken at the time of Christ. Mr. Speaker, our government sends condolences to the Chaldean community and all the Christians of Iraq who suffer persecution. Thank you.
The Honourable Member for Don Valley West.
Mr. Speaker, the International Day of the Francophonie gives us an opportunity to highlight the importance of French for our country, but it is also an opportunity to think about the role that Canada should play among Francophone nations because of institutions like the Toronto French School. Canada must ensure that its participation in this Francophone discussion promotes the French language, but also Francophone values among countries who are members of the International Organization of the Francophonie. Our country can bring forward its views to other countries by showing an example and ensuring that countries that are members of this organization uphold the same principles of justice, transparency, and democracy. By being fully involved in promoting the Francophonie, Canada can make this organization into a credible body that other countries with Francophone populations will want to join. The importance of this International Day of the Francophonie goes beyond the borders of our country, and Canada has a duty to be the proud standard bearer for it.
Mr. Speaker, Canada is concerned that conditions on the ground in Zimbabwe will not allow for free and fair elections that respect fundamental human rights at the upcoming national election on March the 29th. We note the lack of free media, state-imposed restrictions on the freedom of speech, assembly and association, and the use of force by the police against the political opposition. At the last minute, Zimbabwe invited some countries and international organizations to observe and to monitor the elections, but only those expected to provide a positive assessment. Canada was not invited, nor was any international organization of which Canada is a member. Mr. Speaker, Canada is concerned about the prospect for violence in Zimbabwe during the period surrounding the election. Canada calls on the government of Zimbabwe to ensure that all human rights are respected. Merci,
The Honourable Député de Joliette.
The Honourable Member for Joliette. Mr. Speaker, March 17th, as the tradition goes, is the time when we celebrate St. Patrick's Day and the contribution of the Irish to Quebec's development. On March 16th, we will have the traditional St. Patrick's Day parade in the streets of Montreal, which will be carried out regardless of the weather. Year after year, all in green, the color of Ireland, we have this wonderful parade. And in Rawdon, in my riding, we have the second largest parade in Quebec. The Irish left Ireland en masse because of epidemics and famines in the 19th century, and they have come in many cases to Montreal. I invite you to join in the activities organized to celebrate St. Patrick's Day.
Honourable Member for Niagara West, Glanbrook.
Thank you, Mr. Speaker. As we rise today after a productive winter session, it is worth recapping the many accomplishments of this government under a strong leadership of our Prime Minister. Canadian families are safer today thanks to the Tackling Violent Crime Act, a bill that imposes mandatory minimum sentences on gun criminals, will keep repeat violent and sexual offenders behind bars and protect children by raising the age of sexual consent from 14 to 16. This passed with the help from the Leader of the Opposition and the Liberals. The Canadian economy is now on a responsible and prudent course as Budget 2008 is passed, and we have a balanced budget that pays down more than $10 billion of debt and which provides Canadians with a powerful new way to save through tax-free savings accounts. This budget passed thanks to the help of the Leader of the Opposition and the Liberals. The Canadian forces serving in Afghanistan now have a clear support of Parliament. A consensus motion extending the military mission in Afghanistan to 2011 was passed last night thanks to the help of the Leader of the Opposition and the Liberals. The Conservative government announced real greenhouse gas reduction plan, the first to ever include mandatory emission reduction targets. An NDP environmental motion declaring non-confidence in the Conservative government was defeated with the help of
the Honourable Member for Hull-Aylmer. Thank you, Mr. Speaker. I'm sad to highlight today the death of a young firefighter in Val-des-Monts. He was just old enough to become a firefighter. He was 18, and he had been working for the municipality firefighting service for just 6 months. Despite his young age, he was very mature. He died tragically doing what he always wanted to do, which was to help other people. The great family in the Outaouais expresses its condolences. We had great faith. We have great faith in our firefighters, and we salute them for their perseverance and their courage. I want to express on behalf of our colleagues here to our condolences to his family and to his colleagues.
Member for Kitchener-Conestoga.
Mr. Speaker, as we prepare to rise after an extremely productive winter session, I'd like to take a moment to reflect on one of the very significant things we've accomplished for Canadians. As my colleague has stated, Canadian families are now safer due to the passage of the Tackling Violent Crime Act. This Conservative bill that will impose mandatory minimum sentences on gun criminals keep repeat violent and sexual offenders behind bars, and protect children by raising the age of sexual consent from 14 to 16 is now law. Kitchener-Conestoga residents asked me to represent them on these very issues, and it's gratifying to see the results were delivered on their behalf, with the help of the Liberals in the Senate, who helped pass this Conservative bill. Mr. Speaker, the Conservative government wants to wish all Canadians a safe and happy Easter break.
The honourable member for Trinity Spadina.
This month alone, the Conservative government has taken the wrong direction on climate change, extended the war in Afghanistan, and offered no solutions for the doctor shortage or help our cities prosper. But despite the depressing scene on Parliament Hill, Torontonians are working together and taking action. On February 20th, a massive 6-alarm blaze destroyed 14 addresses on a historic part of Queen Street West in downtown Toronto. Some 20 families were made homeless, dozens made unemployed, and shops, some in business since 1914, were destroyed. But Toronto's spirits of generosity and an engaged community came together to raise money, put on benefits, donate clothing and furniture, and help the people affected by this devastating fire. The Queen Street community's unique spirit, dynamic activism, diversity and talent is what makes it so special. And I want to take this opportunity to thank all the volunteers and the local councillor in making the rebuilding of people's life in this historic building possible. I want to urge all members to help out and donate.
L'honorable député de...
The honourable member for Beauséjour. Mr. Speaker, I would invite all of my colleagues to join with me in celebrating the Week of the Francophonie. Our country is based on two main languages, two founding languages, and we celebrate this. The French language is a link that brings us in contact with millions of Francophones around the world. Our values of peace and prosperity are strengthened by our belonging to this great family of the Francophonie around the world, across our country, and in Acadia, which I proudly respect here. We are celebrating this important value in culture. This is a particularly important value in our school system. The teachers have many activities this week they can do with their children. I want to wish us a good week.
Monsieur le Président.
The Honourable Member for Gatineau. Mr. Speaker, the Outaouais Film Festival is being held from March 14th to 21st under the chairmanship of Lucie Laurier. There are some 50 films from 17 countries that will be shown. The first film is Caramel by Nadine Labaki. To close the festival, the founder, Didier Faré, has chosen Ennemi Intime by Florent Emilio-Siri. A gala will be held to celebrate the 10th anniversary of the festival, beginning with the film Les Faussaires, which won an Oscar for Best Foreign Film. Quebec films will be featured with Continental Parfait and Les Trois Petits Cochons, and many others. My colleagues in the Bloc Québécois join with me in congratulating the organizers, volunteers, and we invite everyone to attend.
Mr. Speaker, in just 2 years, this Conservative Party has gone from rhetoric and bluster about accountability to stories of shadowy Conservative operatives working on behalf of this Prime Minister, offering financial inducements to a man suffering from terminal cancer so that he would overturn a democratically elected government. I can't help but look across at the aisle at my colleagues from the Conservative Party and wonder where it all went wrong. It must be disheartening to those sitting in the government benches. So much for ideals, so much for promises they made to their constituents. Instead, they watch and listen every day to the changing story of this Prime Minister. The same Prime Minister whose voice was recorded, the same Prime Minister who said financial considerations were on the table. Mulroney had Fred. This Prime Minister has Flanagan and Finlay. All F's, not very good grades, not good at all, Mr. Speaker.
That's right.
Honourable Member for Nepean Carleton.
Dalton McGuinty did two things upon taking office, Mr. Speaker. First, he hammered the middle class with the biggest tax increase in Ontario history, the McGuinty health tax. Secondly, he raised taxes on Ontario businesses, targeting them and making them less competitive. Because of McGuinty's regime in this province, Ontario has the highest tax on new business investment anywhere in the developed world. Mr. Speaker, Dalton McGuinty never met a tax he didn't hike. And make no mistake, these high taxes kill Ontario jobs. However, it's never too late to do the right thing. Mr. McGuinty has a budget coming up this month, and we would encourage him to do what we've done at the federal level. Cut taxes for investors, entrepreneurs, and their workers. Liberate our economy. Let the eagle out of the birdcage, Mr. Speaker. Let's build our economy on low tax and high competitiveness. Thank you.
Oral questions. Questions orales. L'honorable député de Wascana.
Speaker, yesterday the Prime Minister again tried to dodge that damaging tape that caught him talking knowledgeably about an offer to Chuck Cadman. He has admitted in this House that it was indeed his voice mentioning the offer to Chuck to replace financial considerations by people legitimately representing the party. But yesterday, for the first time, the Prime Minister claimed the tape had been tampered with. If that's true, why did it take over 2 weeks to say so? And will he table the complete, unedited tape in this House right now?
The Honourable Parliamentary Secretary to the Minister of Public Works.
Thank you, Mr. Speaker. The Liberals keep changing their story, but the facts remain the same. Mr. Speaker, first, of course, the Liberals said that there was a meeting on May 17, 2005. They were wrong. The Liberals said that we offered Chuck Cadman a $1 million life insurance policy, and that's false. The Liberals said Chuck Cadman was not going to run again. That was false. The Liberals asserted that I was somehow involved in organizing a meeting, and that was, of course, false. You know, the Liberals claim outrage, but they've had this story for well over a year, and yet they continue to ask questions. If they were really sincere about their outrage, they would have asked these questions long ago, Mr. Speaker. As the Prime Minister has said, when this issue goes to court, all the facts will be on the table, and the Liberal Party will be sorry for what they've said.
Look, member for Wascana.
The Parliamentary Secretary answers everything but the question. The tape is from author Tom Zatarik. He made it public. Donna Cadman and her family stand by their statements that Conservatives did make an offer to deal with their financial insecurity. That's consistent with the tape. If it is all false, why isn't the Prime Minister suing the source of the allegations, Mr. Zatarik, and the Cadmans? Isn't it true that his political lawsuit against the official opposition and now this tale about a tampered tape are all a desperate dodge to avoid confronting the Prime Minister's very own words?
The Honourable Parliamentary Secretary to the Minister of Public Works.
Well, Mr. Speaker, the Prime Minister of this country, just as any Canadian citizen, from the newest Canadian citizen who was sworn in yesterday to the Prime Minister of this country, has the right to defend themselves from false accusations. And it's only the Liberal Party of Canada that has falsely accused the Prime Minister of this country of a crime. He has a right to defend himself, and that's exactly what he's doing.
The Honourable Member for Wascana.
Mr. Speaker, the Prime Minister is claiming that Mr. Zatarik doctored the recording. So he must find the tape as released by Zatarik to be truly damaging. Otherwise, why attack it? Is it because of that specific mention of the offer to Chuck? Is it the references to financial considerations, financial insecurity, financial issues? Is it the admission that the people who made the offer were legitimately representing the party? It's easy to clear the air here. Why won't the Prime Minister just table his own tape on Greywald, so to speak?
The Honourable Parliamentary Secretary to the Minister of Public Works.
Well, Mr. Speaker, as I've said, the Liberals have falsely accused the Prime Minister of this country of a crime. This will be seen. This will see the full light of day in court, and the Liberals will be sorry for what they did. The Prime Minister of this country has been consistent and has been consistent on this issue. I've answered all the questions that have come before this House of Commons, as has the Prime Minister of this country, and the Liberals should apologize for what they've done in this matter, which has falsely smeared the Prime Minister of this country without any evidence whatsoever.
The Honourable Member for Kitchener Centre. Order.
Mr. Speaker, libel cases begin with a process called examination for discovery, where the Prime Minister will be compelled, under oath, to answer all the questions he is not answering here. Why is the Prime Minister waiting for a judge to force him to give Canadians answers? Why won't he simply explain, here and now, why his own voice on a tape confirms he knew representatives were going to have discussions with Mr. Cadman about financial considerations?
The Honourable Parliamentary Secretary to the Minister of Public Works.
Mr. Speaker, it sounds to me like the Liberals don't like that part of law that allows people to sue other people for making libelous accusations against them. So perhaps I would ask the member for Kitchener Centre, was she outraged? Was she outraged when the leader of the Liberal Party in 2005 issued a $400,000 lawsuit against the leader of the Bloc Québécois himself for false accusations that he said were made against him? The Prime Minister of this country, just like the leader of the Liberal Party, has a right to defend himself, and that's exactly what he's doing.
Member for Kitchener Centre.
The Prime Minister can try to stop us from asking questions by launching lawsuits, but it's not going to work. He can stonewall this House and even shut down the Justice Committee to prevent an investigation from happening there. But he will not be able to dodge these questions when he is in court and under oath. Why won't the Prime Minister simply tell Canadians why he didn't stop Conservatives who, by his own admission, were legitimately representing the party from discussing financial issues with Mr. Cadman in order to try to get him to switch his vote?
Honourable Parliamentary Secretary to the Minister of Public Works.
Again, Mr. Speaker, the accusation is entirely untrue, and as I've said before, the Liberals don't have to take my word for it or that of the Prime Minister's, but all we ask is that they take the word of Chuck Cadman himself, who, again, when he was asked on CTV, Mike Duffy, if we were making any offer that was inappropriate, he was asked, and he said that the only offer was an unopposed nomination. Pressed again on the issue by Mike Duffy, Chuck Cadman said, yes, that was the only offer on anything that I had from anybody. You know, they can cite Donna Cadman. Donna Cadman has said that she trusts and believes in the Prime Minister of this country. So do Canadians. And when this comes to the light of day in law, the Liberals will be sorry for their false accusations.
The Honourable Member for Joliette. Mr. Speaker, with the lawsuit tabled yesterday, the Prime Minister is trying to rewrite the Cadman affair. He says that he wasn't. He even ignores some of the interviews made back in September. But a few minutes later, he made a statement that he knew before the vote, 3 months before the vote, that the offer made to Mr. Cadman was with respect to financial consideration. Does the Prime Minister realize that cover-up is useless, and he needs to tell us what exactly he means when he talks about financial considerations? The Parliamentary Secretary, Mr. Speaker, there is no cover-up, they're just the facts. And as I said yesterday, I do agree with the Deputy Leader of the Opposition when he said that the basic question, or the fundamental question, is as follows. Did a member of Parliament was offered a financial inducement to change vote? And the answer to the question is no. The Honourable Member for Joliette. Mr. Speaker, the Prime Minister claims that the tape was altered, but he has no evidence to prove this. What he can't deny, Mr. Speaker, is that on the tape we hear very clearly his voice saying that there were financial considerations made to Mr. Cadman. Can we know what financial considerations, what this meant? And was this an attempt to buy Mr. Cadman's vote? The Honourable Parliamentary Secretary to the Minister of Public Works. There were no offers made to Mr. Cadman except the offer that Mr. Cadman mentioned himself. That is, that he would rejoin the caucus and run as a Conservative member and be elected as a Conservative member. But Mr. Cadman said this himself, and we should take his word as being as the truth. The Honourable Member for San Bruno, Sunnyvale. The Conservatives show a lack of transparency. The former Justice Gomery suggested that we should avoid abuses made by the Prime Minister's office and the government. What the Conservatives in their election campaign said they would do something with this report, but they did nothing. Does the Prime Minister realize that the Conservatives are just like the Liberals, or even worse? The Honourable Government House Leader. That's not true, Mr. Speaker. Yesterday, we had an example of steps taken by our government. In the House of Commons, we voted on a resolution with respect to the future of the Afghan war, and here I refer to our military mission, and that is only, it's our government is the one that has made such a decision in this House. That's an example showing that the approach of our government is different from the previous government. The Honourable Mr. Speaker, but the Afghan war, the military police commissions shows that this is an example of the Conservative government. They know that there are allegations of torture, but the Minister of Foreign Affairs refuses to give full access to certain documents that are essential to the investigation. Isn't that once again evidence that we can't trust this Conservative government and that we have to include the criteria of public interest in the Access to Information Act right now? The Honourable Minister of National Defence. Mr. Speaker, unfortunately, the member is not accurate. It's clear that our government is cooperating with this commission. We had a letter put on the table yesterday. We're explaining the situation. The government will continue to cooperate with the future commission, and all federal departments are prepared to cooperate. Documents with respect to necessary for this commission will be tabled. The Honourable Member for Vancouver East.
Emmanuel Montegrino is the Prime Minister's lawyer. He is also now registered to lobby the Conservatives to approve the sale of radar-sat technology to an American weapons maker. Considering that Mr. Montegrino's regular contributions to the Prime Minister's Conservative campaigns, wouldn't the government want to keep their promise of openness and accountability and tell the Prime Minister's Council to stick to practicing law and not political lobbying?
Honourable Government House Leader.
Mr. Speaker, in our new Tough Accountability Act, we brought in sweeping provisions, including those which extended to lobbying and further effort to ensure transparency, more sweeping than has ever been done under any previous government. Let me assure you that when the Minister of Industry makes the decisions he's required to make in this, it won't be one that is determined by lobbyists. It's a decision that will be determined entirely by the best interests of Canada. He takes that responsibility very seriously, and I think all of us in this House know he will take it on that basis.
Honourable Member for Vancouver East.
Well, Mr. Speaker, that answer is exactly why Canadians don't trust this Conservative government. It's very simple. Mr. Montegrino is the Prime Minister's lawyer. He is lobbying for approval of the unethical sale of Canadian radar-sat technology to an American weapons maker in violation of our national interest, putting Canadian sovereignty at risk. You know, the Conservatives promised accountability. So why is the Prime Minister's lawyer and longtime friend lobbying a minister for a rotten deal that should never go through?
The Honourable Government House Leader.
Mr. Speaker, this government has taken great steps to advance and assert our sovereignty on the world stage, much more strongly than has happened under previous governments. We've seen that with our initiatives in the North, where we're extending Canadian sovereignty with serious commitments and investments, and we're seeing that with our action elsewhere on the world stage. In terms of the transaction in question, the decision will be made on a simple basis. What is in Canada's best interest? That's how the Minister will make that decision.
The Honourable Member for Laval-Les-Îles. Mr. Speaker, Brenda Martin, who is in a Mexican jail, is at the end of her rope, but the government is lagging, and we are even fearing for Ms. Martin's life. She is so desperate that she says that she's now thinking of committing suicide. What is this government waiting for to give her some shred of hope? Because the ministers are not competent. Will the Prime Minister then pick up his phone and try and help Miss Martin? The Honourable Parliamentary Secretary.
And about Miss Martin's health, we have expressed our strong concerns to the Mexican authorities regarding inappropriate conditions of her detention, delays in bringing her case to the trial, lack of translation facilities. Mr. Speaker, I want to assure all Canadians and Miss Martin that the coming weeks the Government of Canada will continue to press for a quick positive resolution to this case. Thank you.
The Honourable Member for Laval-Les-Îles.
I'm not at all certain that the Canadian people really accept this answer. The Secretary of State for Foreign Affairs would not even take Ms. Martin's phone call. The Secretary of State could not even be bothered to visit Ms. Martin in jail when she was only 20 minutes away. When she was asked why she didn't visit Ms. Martin's cell, where she was crammed with 11 other prisoners, the Secretary answered, "It's not my job." If it's not her job to help Brenda Martin, will the Prime Minister use this buckwheat to fill the void and make the case to have Ms. Martin immediately return to Canada?
The Honourable Parliamentary Secretary.
In my answer, that the government has made the highest representation to the Mexican authorities. The foreign minister just called the foreign minister of Mexico just last week to express his strong concerns on this case, Mr. Speaker. And I can assure again to the Canadians and Ms. Martin that we will continue to talk to the highest levels of the Mexican authorities to have a quick positive resolution to this case. Thank you, Mr. Speaker.
Honourable member for Dartmouth Cole Harbour.
Mr. Speaker, the Minister of Foreign Affairs continues to hide behind his so-called investigation into the leak of confidential diplomatic information that continues to interfere in the U.S. presidential election. He won't release any details, he won't give us any facts, and he expects us to trust him on this one. Unfortunately, when it comes to trust, this government's record is miserable, and Canadians know it. Will the minister ask Ambassador Michael Wilson to step aside during this investigation to prevent any further leaks and any further damage to our relationship with the United States?
The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
The Prime Minister has already said we take this matter very seriously. But I want to tell something, Mr. Speaker. NAFTA has been a very, very good agreement between Canada, America, USA. It has helped raise the living standards, and it is touted as one of the best trade agreements. Not also that, but we take our relationship with our southern partners very seriously. It's a strong relationship, and we will continue furthering this relationship, Mr. Speaker. But as I've said, as the Prime Minister has said, as the Minister of Foreign Affairs has said, investigation is going on and appropriate action will be taken when the results are out. Thank you, Mr. Speaker.
Honourable member for Dartmouth Cole Harbour.
Well, Mr. Speaker, that's no answer, so let me make it specific and easy for the government. Article 41.1 of the Vienna Convention on Diplomatic Relations says of relations between nations, and I quote, "The government has a duty not to interfere in the internal affairs of that state." That seems pretty clear, Mr. Speaker. Has the minister even sought a legal opinion as to whether Michael Wilson's involvement in the NAFTA leaks constituted a breach of this international convention?
The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
I fail to understand why they don't listen to what I've just answered, which is very clear, Mr. Speaker, straightforward. The investigation is going on. When the results are in, we will take appropriate action as deemed necessary. But I would like to tell the honourable member, even the U.S. Ambassador to Canada, has said this matter is now over. We take our relationship very seriously with our southern partners, and we will continue strengthening our relationship. Thank you, Mr. Speaker.
The honourable member for Drummond. Mr. Speaker, in the case of Omar Khadr, this young Canadian who has been in Guantanamo, we learned that the American surgeon who interrogated him is now before a court-martial court where he is being accused of torturing during hearings. He's even suspected of causing the death of one of them. Mr. Khadr has been exposed to cruel treatment and inhumane treatment. What is the government waiting for? Why not bring back this Canadian so that he can be put on trial here at home? The Honourable Parliamentary Secretary of the Minister of Foreign Affairs.
Mr. Speaker, Mr. Khadr faces very serious charges. The Government of Canada has sought and received assurances that Mr. Khadr is being treated humanely. Mr. Speaker, department officials have carried out several welfare visits with Mr. Khadr and will continue to do so. Thank you, Mr. Speaker.
The Honourable Member for Drummond. Mr. Speaker, we also learned that an American officer amended a report in order to throw blame on young Khadr. The first report, the original, said that the assailant had been killed. Mr. Khadr is therefore not concerned in this affair. Given all these facts, the government has no reason to wait. When will it act to bring Omar Khadr home? The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Mr. Khadr faces serious charges. At this current time, the case is going on, legal process is on, appeals are on, Mr. Speaker. But from Canada's point of view, we'll continue visiting Mr. Khadr to see his well-being. And, Mr. Speaker, I can assure that we have asked the U.S. to treat him humanely. Thank you, Mr. Speaker.
The Honourable Member for Argenteuil-Papineau-Mirabel. Mr. Speaker, on Wednesday, the Finance Committee adopted a report urging the government to increase its aid plan for the manufacturing and forestry sectors from today's surplus. While millions of jobs are threatened, will the government give in to the will of parliamentarians and stop its policy of putting everything on the debt and increase its aid by March 31st? The Honourable Parliamentary Secretary, or Secretary of State, rather.
Mr. Speaker, the Minister of Industry has made it clear on numerous occasions that this government has given literally billions of dollars in assistance to the manufacturing sector in the term of tax breaks, in the terms of direct funds of money to assist this sector. It's never enough for the member opposite. I don't understand why he thinks that the manufacturing sector is not able to make use of the substantial assistance that this government has provided. He needs to have a little bit of more faith in...
L'honorable député.
Honourable member for Argenteuil-Papineau-Mirabel. Mr. Speaker, no compassion for the jobs lost. The IMF is inviting member countries to increase public spending to stimulate growth, which is being threatened by a worldwide slowdown, including, according to the Institute for Policy Analysis, Quebec and Ontario may already be in a recession. Will the minister open his eyes and use part of the surplus, $13 billion, before March 31st? He has time, and he should certainly well afford it. The Honourable Parliamentary Secretary to the Minister of Finance.
Thank you, Mr. Speaker. And I might add to the previous answer that was given in this House. Quebec alone received $400 million in equalization payments, Mr. Speaker. That's what this government put together as a start. There was a system in this country that was not equal. That's where we started, Mr. Speaker. We've included tax cuts, $10 billion in tax relief to industries. We've put forward a $1 billion community development trust fund to help those people that are impacted in one industry towns.
The honourable member for Ottawa South.
Mr. Speaker, this government is so desperate to close the door on immigrants that it will ignore the painful mistakes of previous Conservative governments that tried to do the very same thing. Diefenbaker tried to shut out immigrants by capping the system, only to abandon his plan a month later because his policies were short-sighted and misguided. Why does the minister insist on closing Canada's doors to the newcomers we desperately need to fuel our labour and our population growth, even though history shows this is absolutely the wrong approach?
Minister of Citizenship and Immigration.
Well, Mr. Speaker, the member opposite is absolutely wrong. In fact, last year, this Conservative government welcomed more immigrants to Canada than has been done in almost 100 years. 400. And, Mr. Speaker, not only are we doing more, we're doing it better. In the family reunification class, we've made that a priority, and now cases are getting processed 20 to 40% faster than they did under the previous government. Mr. Speaker, we're making great strides in cleaning up the Liberals' immigration mess.
The honourable member for Ottawa South.
Some progress, Mr. Speaker. A 100,000-person increase in the backlog in 26 months. I'd ask the minister to get to work and not by closing the doors on immigrants. Monsieur le Président.
Mr. Speaker, let's be clear. They claim that Canada has 429,000 new arrivals, but this is falsely inflated by students and temporary workers. Why is the government trying to circumvent attention from their plan to considerably reduce the number of newcomers to the country by trying to vaunt their meager track record on immigration?
It has two objectives. The first is to bring more newcomers here to fill the jobs and be reunited with their families. The second is to do it faster. Let's contrast that with the Liberal record on immigration. They ballooned the backlog from 50,000 to 800,000. They took processing times from 3 to 6 months to 3 to 6 years. Mr. Speaker, they voted against reducing the head tax that they brought in. They voted against launching the Foreign Credentials Referrals Office. Mr. Speaker, we're fixing the Liberals' immigration mess.
The honourable member for Esquimalt-Wanda-Fuca.
Mr. Speaker, yesterday every government member voted to rebalance our mission to Afghanistan. A new report by the Canadian Council for International Cooperation clearly shows that peace efforts in Afghanistan are in disarray and they are not supported by the international community. It calls on Canada to rebalance our mission, which is crucial to the mission's success. So my question to the Minister of Foreign Affairs, what specific plan is his government going to offer to achieve the tribal reconciliation that is absolutely crucial for the success of our mission to Afghanistan.
Honourable Minister of National Defence.
Thank you very much, Mr. Speaker. I thank my colleague for the question. In fact, this government has been moving in the direction for some time to put greater emphasis on the training component, greater emphasis on cultural sensitivity around the issues that relate to interaction with the people of Afghanistan. We, of course, have committed over $1 billion, most recently in this budget $100 million, specifically for issues around infrastructure, around investment, around programs, so that more kids can be in school, more women can access microcredit financing, more effort can be made to develop the situation in Afghanistan so the people themselves can do more for themselves in their country.
Honourable Member for Esquimalt-Guandafuca.
Speaker, it's important how much we spend, but it's more important that we spend that money effectively. Mr. Speaker, the Liberal plan offers that peace will only occur in Afghanistan if the people can provide for their own security. So I'd like to ask the Minister this question. Will he support our plan that his government take to Bucharest a very specific position for NATO to set timelines and hard targets for the Afghan people to be able to have their own Afghan police, army, corrections and judicial personnel that are properly paid, trained and equipped? These 4 pillars for Afghanistan security are crucial.
The Honourable Minister of National Defence.
Mr. Speaker, that is again, of course, exactly what Canada and what NATO are doing, Mr. Speaker. And as usual, we're seeing an after-the-fact recitation from the honourable member about what he would like to see happen, Mr. Speaker. He, in fact, and his party supported the vote last night to extend the mission. We thank him for that support. It is now a Canadian position that was endorsed by the Parliament of Canada. This is good news for the soldiers, for the aid workers, for the diplomats who are doing this important work on behalf of our country. It's something that should be a source of pride for all Canadians. And aside from the partisanship, Mr. Speaker, I think that this is something that Canada in the future will look back upon as a tremendous historic vote and confidence for our soldiers.
Honourable Member for Selkirk-Interlake.
Mr. Speaker, yesterday retired Justice John Gomery appeared at the Government Operations Committee and spoke on ethics and accountability. It has come to light that 2 former employees of the Liberal Party with links to the sponsorship scandal were hired to work on Bob Rae's leadership campaign. Oh, no. I wonder if they're working on his campaign right now in Toronto Centre. After Canadians fired the Liberals for their lack of ethics, our government was elected on a promise to clean up government. Can the Parliamentary Secretary, through the Treasury Board President, tell the House what measures we have taken to bring back accountability?
Honourable Parliamentary Secretary to the President of the Treasury Board.
Great question, Mr. Speaker. Yesterday, Judge Gomery indicated that he still has not found the $40 million in missing Liberal dollars. He also pointed back to his report, which said that a Mr. Gaetano Maggianiello was part of the sponsorship scandal and accepting part of the $82,000 that was paid to Pluri Design, that company for which he did not actually work. This individual is now part of the Bob Rae team and helped him in his leadership campaign, which means that Bob Rae, who wrote the Liberal election platform, is the worst part of the NDP free spending and Liberal scandal. Bad hybrid, Mr. Speaker.
For Ottawa Centre.
Speaker, it isn't yet a foregone conclusion that Canada will be at war in Afghanistan for another 3 years. For the extension to come into effect, NATO needs to come up with an additional 1,000 soldiers and the deployment of medium and heavy lift capacity. To date, no official announcements have been made on additional troops committed to the war or planned procurement of airlift capacity. Mr. Speaker, will the Minister of Foreign Affairs clarify today if these conditions are not met, Canada will not extend its combat mission in Afghanistan?
The Honourable Minister of National Defence.
Well, Mr. Speaker, I would like to thank the member. No, wait, I'm sorry, I can't thank the member for his support for the motion last night. But in fact, Mr. Speaker, what did occur is that the Parliament of Canada took the position that Canada would continue in Afghanistan. We would continue a whole-of-government approach, which does include, of course, giving our men and women in uniform the necessary equipment to carry out this mission, to execute the security perimeter that will allow for greater development, greater efforts at the humanitarian relief, Mr. Speaker, that's taking place in that war-torn country. Canada should be very proud of that effort, and we're looking forward, Mr. Speaker, with the support of the Liberal Party, to seeing that this mission continue and that the resources are necessary.
The Honourable Member for Ottawa Centre.
Speaker, my conscience is clear. I don't know about those on the other side. The Manley report spoke very critically about the lack of coordination of combat operations in Kandahar, and from all accounts, the situation will likely only get worse, not better. If the only NATO ally coming forward with additional troops is the United States, can the government explain whether the Marines will come under the command of NATO or the command of Operation Enduring Freedom? And if they do fall under a separate command, how is having two parallel combat missions in the same place at the same time helping to rectify the coordination problems that exist?
The Honourable Minister of National Defence.
Well, I see the member has been reading his latest copy of Esprit de Corps magazine, Mr. Speaker. I know he's a subscriber to that, and he's up to date on some of the latest tactical maneuvers happening in Afghanistan. Mr. Speaker, this is an ISAF mission. Mr. Speaker, it has the United Nations Security Council resolution. It's a NATO-led mission, Mr. Speaker. There is efforts being made that will help to eradicate one of the worst exporters of terrorism that the world has ever seen. The member opposite would suggest that we could send a combat unit of mimes to Afghanistan, Mr. Speaker, would withdraw all the soldiers, and then we would have to, of course, withdraw all the aid workers as well.
Honourable Member for Welland.
Speaker, in this most unaccountable government, the Environment Minister is implicated in the Larry O'Brien bribery case, while doing more damage than good to the environment. The Health Minister ignores his promise on hospital wait times. The Finance Minister undermines Ontario's economy by calling it the last place to invest. And the government House Leader insults his promise as Premier. Mr. Speaker, why is the Prime Minister sitting back and allowing his Gang of Four to wreak havoc on this country the way they did on Ontario when they were at Queen's Park?
Exactly.
The Honourable Government House Leader.
Mr. Speaker, there is one thing that we did learn from that time, and that's the importance of doing exactly what you said you would do. And that's what this government is doing. We're delivering on our commitments with the toughest Accountability Act ever in Canadian history. Exactly. We promised it. We did it. We committed to reduce taxes, reduce the GST, reduce personal income taxes. We said it. We did it. We delivered it. We said we would take action on the environment. We said it. We did it. We would deliver it. And each one of these promises, each one of these commitments, tackling violent crime, same thing. We said it. We did it. We delivered. The only thing that stood in our way is the Liberals. Well, not the Liberals.
The Honourable Member for Welland.
Mr. Speaker, let's not beat around the bush. Four of this government's most prominent ministers continue to insult the intelligence of Ontarians. Ontario deserves its democratically allotted seats. Ontario does not deserve this unaccountable government. 2-1, Ontarians believe in a balanced approach, not a Mike Harris approach to its economy. Right. Mr. Speaker, Ontarians deserve a government and its elected Conservative MPs to step up and represent them. Will the Conservative government apologize for the actions of its ministers?
Yes, exactly.
The Honourable Government House Leader.
Mr. Speaker, the member is absolutely right in this regard. Ontario deserves members of Parliament who will stand up for them. And guess what? When it came to tackling violent crime, where were the Liberals? Sitting in their seats. When it came to tax cuts, where were the Liberals? Sitting in their seats. When it came to ensuring we continue to have a balanced budget and a good fiscal framework, where were the Liberals? Sitting in their seats. In fact, I look at the ranks today, I think there must be a vote coming today.
Honourable Member for London West.
Mr. Speaker, the Finance Minister has gone on a crusade to undermine the Ontario economy by calling it the last place to invest. Why is the Finance Minister determined to use his federal position to wreak havoc with the Ontario economy the way he did when he was the Mike Harris Treasurer?
Right on. Honourable Parliamentary Secretary to the Minister of Finance.
Well, Mr. Speaker, I might quote the Honourable Minister who stated yesterday in this House that he is hopeful that Premier McGuinty's provincial budget on March 25th will provide long-term, broad-based support by reducing its provincial corporate income tax, by making a commitment to fully eliminate capital tax for businesses in all sectors. Mr. Speaker, it is the Finance Minister's role to encourage all provinces to get up to speed, to get up to where other provinces are, to encourage investment, Mr. Speaker.
Well, Member for London West.
Well, Mr. Speaker, the Finance Minister's double talk does go further. The man who pretends to balance the books actually left a $5.6 billion deficit when he was a provincial finance minister. He claims he supports infrastructure and Ontario communities, but calls them whiners. And he says he's not in the, quote, pothole business. Well, Mr. Speaker, when will the Finance Minister censor himself instead of the Canadian films for the benefit of the public good.
The Honourable Parliamentary Secretary to the Minister of Finance.
Well, thank you, Mr. Speaker. And the federal finance minister is absolutely within his jurisdiction to encourage that all provinces get up to the same investment opportunities that, such as British Columbia, Mr. Speaker. And we can't help but acknowledge what happened in the budget in Quebec yesterday, where the Quebec government has actually decided to abolish capital taxes, Mr. Speaker. That's simply what the finance minister is encouraging the government in Ontario to do.
The Honourable Member for Verchères-les Patriotes. Mr. Speaker, for the Conservatives, the fact that Quebec, which represents 54% of the aeronautics industry, does not get its fair share has no importance, to such an extent that in the contract for 17 Hercules, Quebec will have fewer spin-offs than the Maritimes, which only represent 5% of this industry. The laissez-faire attitude of the Conservatives means do everything against Quebec. When will Quebec ministers stand up so that Quebec gets its fair share of these government contracts? The Honourable Minister of Transport. Mr. Speaker, once again, we see the Bloc Québécois, which is incapable of delivering anything at all for the Quebec voters. So, over the past 2 years, we've solved fiscal imbalance and we've allowed for a balanced budgets in Quebec, $4.5 billion more. We acted on the manufacturing front. We are acting for Quebecers in the aeronautics industry. We deliver the goods contrary to the Bloc Québécois. The Honourable Member for Verchères-les Patriotes. RadarSat-2, an innovative satellite built at the St. Hubert Canadian Space Agency, may go to an American firm. Will the Minister of Industry allow the Canadian contribution and Quebec contribution to research by disregarding intellectual property in all CETA and RDC activities and allowing MDA to be sold to ATK, a company that manufactures munitions? The Honourable Minister of Transport. Mr. Speaker, since we've been in power here, we've established a fair and equitable policy toward all regions. We know full well that Quebec has a very strong aeronautics industry. We've encouraged it. We know that Quebec developed a critical mass for R&D. We've supported that. Mr. Speaker, Quebecers know one thing that's quite clear. When the time comes to deliver the goods, when the time comes to keep our word, we do it. The Bloc cannot do so.
Member for Markham Unionville.
Monsieur le Président.
Mr. Speaker, the Calypso Park in the municipality of La Nation will create 550 full-time seasonal jobs as of 2009. The Ontario government has participated, as has the municipality. But the only thing the Conservatives have done, including the member for Glengarry Prescott Russell, are fine words. They say they support the project, but with no financial support. Why are the Conservatives creating false hopes? The Honourable Minister of Transport. I'm surprised, Mr. Speaker. Here we have a Toronto member who's starting to be interested in Eastern Ontario, in the Greater Ottawa region. I must say, Mr. Speaker, that this government has made a commitment to work with the provinces to come up with a program that will renew infrastructure across the country. My colleague has just announced something for the 174 highway in his riding, which will allow much more to come to his region than other projects proposed by the opposition. The Honourable Member for Wetaskiwin.
The previous Liberal government shamefully did nothing for the environment the entire time they were in power. But that has all changed with this Conservative government, as we are taking real action in the face of climate change. In fact, the former Premier of Quebec, Pierre-Marc Johnson, recently said that with the regulatory measures announced last week by the Minister of the Environment, Canada has gained back its international credibility. Can the Minister of Transport tell this House how he intends to address fuel consumption for the vehicles on Canadian roads and how the Conservative government will continue to deliver real action for our environment and the air that we breathe.
Honourable Minister of Transport.
I want to thank my honourable colleague, Mr. Speaker, for his question, because indeed we are the first government that has committed to reduce greenhouse gases by 20% by 2020. And what, Mr. Speaker, what's interesting is what Pierre-Marc Johnson, the successor to René Lévesque in Quebec, as we all know, what did he say? What did this former premier say? He said, Mr. Speaker, he said the following, Le Canada pourra maintenant...
Canada can now start to talk with credibility again in the international scene by talking about stabilization and concentration of GHGs.
Honourable Member for Trinity Spadina.
Mr. Speaker, new Canadians are getting used to disappointment. Year after year, Liberal governments let the immigration backlogs grow, and the Conservative solution is just as absurd. They just won't take as many applications. Well, if the Conservative government was serious about clearing the backlog, they would have restored all the cuts the Liberals inflicted on Canada's overseas office and relaxed the point system so more families can come. So why, instead, do they put corporate tax cut ahead of family reunification, Mr. Speaker?
Honourable Minister of Citizenship and Immigration.
Well, Mr. Speaker, I can hardly believe that the NDP would have the nerve to ask us about immigration. When we look at their record, let's see. With their record, they voted against an additional $1.4 billion for resettlement funding for newcomers. They voted against the Foreign Credentials Referrals Office. They voted against cutting the head tax on immigrants. And now they want to vote against reducing waiting times. Mr. Speaker, the NDP should be ashamed of themselves.
Honourable Member for Trinity Spadina.
Unbelievable answer, Mr. Speaker. Canada must increase the target number of immigrants into the country to 1% of the population in order to renew our workforce and drive our economy. Now, a Conservative answer is to import massive numbers of temporary foreign workers who are vulnerable to mistreatment and abuse. So why is this government interested only in providing cheap labor to big corporations and not let ordinary family members bring their loved ones here into Canada?
Honourable Minister of Citizenship and Immigration.
Mr. Speaker, we've made significant progress on reuniting immigrant families. In fact, we're now processing those cases 20 to 40% faster than they were before we took office. Mr. Speaker, we want to get families reunited faster and more skilled workers here sooner. That's our objective. We're going to do it even if the NDP continue to vote against us.
The Honourable Member for Malpeque.
Mr. Speaker, we know the Parliamentary Secretary's vendetta against the Wheat Board leads him to say ridiculous things. However, he seriously crossed the line when he attacked the President of the National Farmers Union and released confidential information on Mr. Wells' business through the board. The Minister confirmed yesterday such information was requested, as demanded in Mr. Wells' letter. Will the Parliamentary Secretary apologize for his unsubstantiated, defamatory, incorrect, and disgraceful remarks? Will he stand in his place today and apologize?
The Honourable Parliamentary Secretary.
Well, Mr. Speaker, it's always good to see the Liberals focus on agriculture at 10 after 12 on Friday, because that's the only time they ever ask questions. It's also good to see their disconnect with agriculture, because their questions are always full of misinformation. And I really object to the member today doing what he's doing. And of course, he's following the NDP leader yesterday. The minister answered this question yesterday, and Mr. Wells is actually well known as an organic farmer. If they're accusing me of saying that he was one, the NFU website says that. My question to Mr. Wells has simply been, has he been able to take advantage of the organic grower special buyback this year? And if he has, why is he telling other farmers that they can't have the same deal themselves?
The Honourable Member for Quebec-Quack.
Mr. Speaker, earlier this week, the member from Beausejour publicly accused the government of failing to appoint bilingual judges to New Brunswick benches.
As a member of Parliament from New Brunswick, I am proud of our heritage and the fact that we are the only bilingual province And I want to clarify this insinuation.
Secretary to the Minister of Justice correct this erroneous statement and in the process set the member opposite straight.
The Honourable Parliamentary Secretary to the Minister of Justice.
Monsieur le Président, comme
Mr. Speaker, I'm very pleased to answer this question as a member from New Brunswick.
appointed judges in New Brunswick. Of the 6, 3 are fully bilingual. We are guided by the principles of merit and legal excellence, as well as seeking linguistic competence. As the member of Beauséjour should know, it was his colleague, the member from Moncton River-Dieppe, that said, "They look like pretty good appointments, and I'm glad they're filling the vacancies." We agree.
Honourable Member for Richmond Hill.
Mr. Speaker, the upcoming Olympics has led to crackdowns against human rights advocates in China. This week marks the 49th anniversary of the failed uprising in Tibet against Chinese rule. In recent days, we've seen the arrest and release of Deng Biao, Beijing human rights lawyer and activist, as well as the use of force against protesters, Buddhist monks in Tibet today. What specific steps will this government take to address this situation? I don't want the general platitudes that we heard yesterday.
Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Mr. Speaker, we are alarmed at the deterioration situation, including increasing reports of violence. We have expressed our concerns to the Chinese ambassador and through our embassy in Beijing to the Chinese government. We are asking also that Canada also sought clarification on the current situation in Lhasa, as well as information on the whereabouts and the well-being of Canadians in the affected area. Thank you, Mr. Speaker.
That will conclude the question period for today. Si la Chambre le permet, j'aimerais...
If the House will allow, I would like to come back briefly to the question of privilege raised yesterday by the Honourable Member for Acadie-Bathurst, as well as the interventions by the Honourable Member for Gatineau and the Honourable Member for Ottawa-Vanier. As I mentioned in quoting the procedures and practice of the House of Commons on page 43, I believe, and I quote, that in most instances when a point of order or a question of privilege has been raised in regard to a response to an oral question, the Speaker has ruled that the matter is a disagreement among members over the facts surrounding the issue. As such, these members are more a question of debate rather than a breach of the rules or privilege. End of quote. However, in reading correspondence sent to the Standing Committee on Official Languages by the Minister of Canadian Heritage, Status of Women and Official Languages, I can understand that there may have been a misunderstanding regarding the minister's statement during the question period of March 12th. And given that fact, I feel that it would be appropriate for the Honourable Minister to clarify the facts when the opportunity arises in the near future. So thank you for your attention.
Documents, dépôt de documents. Oh, a point of order first. The Honourable Government House Leader.
Speaker, and it's actually relevant to rising out of the comments you just made. The Minister of Heritage is not here today, but she did want me to table the correspondence before the House that she provided relating to it. The suggestion was, of course, that she had indicated that she wasn't prepared to appear at committee. Her letter to the chair of the committee, February 25th, states quite clearly the opposite. She indicates, "Il me fera plaisir de comprendre."
I will be pleased to appear before the committee to discuss the next phases of the action plan as soon as my work has been completed on that matter.
Explains her answer. If you wish, you could explain it further, but I'm happy to table this document on her behalf.
Another point of order, the Honourable Parliamentary Secretary to the Minister responsible for the Canadian Wheat Board.
Thank you, Mr. Speaker. I just want to address the strange and almost bizarre accusation or mistake that the member from Toronto Danforth made yesterday and the member from Malpeque has made again today. I just want to point out that I have never, in fact, implied, as the member for Toronto Danforth said, that I was aware of the individual business relationship of one farmer, the head of the National Farmers Union, no less than the Canadian Wheat Board. Mr. Speaker, apparently what he was referring to yesterday was my comments where I called Mr. Wells an organic farmer in the House of Commons. I had asked Mr. Wells, as farmers across Western Canada have asked him to explain if he was taking the special deal that the Canadian Wheat Board offers to organic producers at the same time that his organization was taking the position that other farmers should not have those same opportunities. Mr. Speaker, Mr. Wells, his neighbours, his own organization, and the Internet, if you go on it, sir, all recognize him as an organic farmer. So if that was the member's accusation, I guess they've demonstrated once again the failure of their, particularly the NDP's, I guess, research abilities. But, Mr. Speaker, even with those limitations, it seems to me that both the member from Toronto Danforth and the member from Malpeque have the responsibility to make sure that they're accurate and to tell the truth. And so I would appreciate if they would actually have the stomach, the guts to stand up today to acknowledge their mistakes and apologize for their misleading comments. They've misled Western Canadian farmers. They've misled the House as well. And so I'd appreciate that apology.
The honourable member for Malpeque.
Thank you, Mr. Speaker. The incident that I believe the leader of the NDP yesterday brought forward, and myself again today, relates to really a personal attack on that was launched by the parliamentary secretary during the emergency debate on livestock on February 13th in this House, Mr. Speaker, and you can refer to that debate and see the remarks. And I have here, Mr. Speaker, in my hand, I'd be willing to table it, a letter that is directed to the Parliamentary Secretary, Mr. Anderson, but to the Parliamentary Secretary, Mr. Speaker, signed by Stuart Wells, the President of the National Farmers Union, and he states clearly in here, I am writing regarding a personal attack that you launched against me during an emergency debate on livestock on February 13th, 2008 in the House of Commons. You're hiding behind your parliamentary immunity by attacking me in the House of Commons, which I cannot defend myself, nor can I find a remedy for your defamation through the courts. Your comments in the House are unacceptable and a disgrace to you and your party. You've deliberately replied, and this is the meat of the evidence, Mr. Speaker, you've deliberately implied to the House of Commons that you know how I market my grain through the Canadian Wheat Board. The only way you could have any knowledge of my personal business dealings is if you have been abusing your power and investigating my transactions with the Canadian Wheat Board. Now, Mr. Speaker, to the Parliamentary Secretary's point that he just raised, the Minister yesterday, in response to the question by the leader of the NDP, said that that information was requested from the board. So this is a serious matter of commercial confidentiality coming from the board that the member released in this House. Mr. Speaker, Mr. Wells goes on further to say, have you been abusing your office as Parliamentary Secretary and investigating my personal business transactions with the Canadian Wheat Board? Either you have intimate knowledge of my business dealings with the Canadian Wheat Board, or you are lying to the House of Commons when you pretend to know how I market my grain. Which is it? Mr. Speaker, I will conclude by the request that Mr. Wells made, directed to the Parliamentary Secretary. Do you have the integrity required to stand in the House of Commons and apologize to your colleagues and then make a further apology to me for your unsubstantiated, defamatory, and incorrect remarks? End of question. That relates to the point of order raised, and clearly the member has used confidential commercial information in attacking a constituent in his own riding and a president of a national farm organization.
The honourable Parliamentary Secretary, a brief response, but this sounds to me like a dispute as to facts.
It may be a dispute as to the facts. He's also twisting what the minister said yesterday in the House, Mr. Speaker, and so I'd refer you to that as well. He clearly fails to understand the issues here, and so has tried to mislead Canadians, Western Canadian farmers in particular, and I would suggest the House as well.
Is the honourable member for Winnipeg South rising on the same point?
Winnipeg Centre, actually, Mr. Speaker.
Winnipeg Centre, sorry.
On the same point, just briefly, if you will, allow me a moment, Mr. Speaker, as it was the leader of my party that asked the question yesterday that seems to have set this off. We, too, are speaking on behalf of Mr. Wells, who, as a private citizen, as a personal individual, had his personal and private information dragged before the House of Commons in a way that only someone with privileged inside access could have knowledge of. And I just rise to remind the the chair of one ruling in Marlowe-Montpetit that speaks to this, and I hope the parliamentary secretary is taking note, and he will pass this on to the minister from yesterday, in that speakers, page 77, under privileges and immunities dealing with the right to free speech in the House of Commons, Speaker Perron is quoted saying, "Paramount to our political and parliamentary systems is the principle of freedom of speech, a member's right to stand in this House unhindered to speak his or her mind, etc. However, when debate in the House centres on sensitive issues, as it often does, you expect members would bear in mind the possible effects of their statements and hence be prudent in their tone and content of their words." He's speaking about, Mr. Speaker, I'll read one more line, is that speakers have also stated that although there is a need for members to express their opinions openly and freely in a direct fashion, it is also important that citizens' reputations are not unfairly dealt with, and in a ruling on a question of privilege, Speaker Fraser expressed this concern that an individual who was not a member of the House had been referred to by name and noted that this concern had also been shared by some members who had participated in that conversation. So when we drag the personal, confidential, commercial information of a private individual before this House of Commons in a way that could easily be taken as a politically slanted and biased opinion, because, let's face it, the government of the day is virtually at war with the Friends of the Canadian Wheat Board and the National Farmers Union and all farmers who oppose to their ideological crusade to smash and undermine the Canadian Wheat Board. When this minister uses that information to sully the reputation or to try and smear the reputation of a private citizen, they've abused the their privileges of the right to free speech in the House, and left no avenue of recourse for the individual, because the flip side of the coin of members' privilege to say whatever they want in the House is the rights of citizens to be able to defend themselves. They have no such recourse when those comments are made within the parliamentary privilege, and that's why the Speaker has to take care that members don't abuse that privilege and malign private citizens. Thank you, Mr. Speaker.
Is this on the same point of order? The Speaker has heard the points, and I've certainly heard the points that were made today. I thank the Honourable Member for Malpeque. I thank the Parliamentary Secretary and the Honourable Member for Winnipeg South. As the Speaker has stated, the Honourable Parliamentary Secretary might want to take his seat for a moment. As the Speaker has noted, this seems to be a dispute on fact and not a dispute related to a point of privilege. In any event, the Speaker will return to the House if necessary. But I think that the House has heard sufficiently on that topic for the moment. Tabling of documents. The Parliamentary Secretary to the Minister of Human Resources and Social Development.
Mr. Speaker,
the Government House Leader is rising on a point of order.
Indeed, Mr. Speaker.
Is this a point of order or a different one?
Point of order. In fact, I simply wish to do the following. I would have had an opportunity to do this on Thursday. However, the Opposition House Leader did not conduct the usual role of the Opposition House Leader in asking the Thursday question. And as a result, there has not been an opportunity, because of the failure of the Opposition to play their traditional role, to advise the House of the following. So at this time, I would like to designate Monday, March 31st, Tuesday, April 1st, and Wednesday, April 2nd, 2008 as allotted days. Those will, of course, be our first 3 days back after the Easter break.
Hear, hear.
I thank the Government House Leader for responding to the Thursday question that wasn't asked. Tabling of documents.
Thank
I recognize the Parliamentary Secretary, the Minister of Human Resources and Social Development.
Yes, thank you, Mr. Speaker. Pursuant to Standing Order 36.8, I have the honour to table in both official languages the government's responses to 7 petitions.
Introduction of government bills. Mr. Cannon Pontiac. for Mr. Flaherty, seconded by Mr. Van Loan, moves for leave to introduce a bill entitled An Act to Implement Certain Provisions of the Budget tabled in Parliament on February 26, 2008, and to enact provisions to preserve the fiscal plan set out in that budget. Cette motion est réputée.
This motion is deemed adopted.
Mr. Cannon for Mr. Flaherty, seconded by Mr. Van Loan, moves that the bill be now read a first time and be printed. Cette motion est réputée adoptée.
This motion is deemed adopted.
This bill, première lecture de ce projet de loi.
When shall the bill be read a second time? At the next sitting of the House. Statements by ministers. Reports from interparliamentary delegations. Présentation de rapports de comité.
Presenting reports from committees.
Dépôt de projets de loi émanant des députés.
Introduction of private members' bills.
First reading of Senate public bills. Motions. The Honourable Member for Mississauga South, Mr. Szabo, seconded by Mr. McGuinty, moves that the third report of the Standing Committee on Access to Information, Privacy and Ethics, presented on Friday, February 29, 2008, be concurred in. Debate. The Honourable Member for Mississauga South.
Thank you, Mr. Speaker. The particular report from the Standing Committee on Access to Information, Privacy and Ethics says, in part, Mr. Speaker, as the committee has now completed its examination of witnesses in the matter of the Mulroney-Airbus settlement, that the government immediately initiate a formal public inquiry into the Mulroney-Schreiber affair. Mr. Speaker, the committee, in fact, has been the subject of much news. And, in fact, the last report I saw was that we've conducted 4 months of hearings. The fact is, Mr. Speaker, that, in fact, we only had 11 hearing days, only heard from 12 witnesses, and only had 25 hours of, in fact, testimony from those witnesses. We did, however, Mr. Speaker, receive some 3,000 pages. Having said that, Mr. Speaker, I can think of no other proceeding at a committee that I've been at where I've heard more contradictions, more discrepancies, and in fact, more situations where people are clearly not being truthful with the committee. Mr. Speaker, this is very important because we have now had a situation where the government has indicated clearly there will be a public inquiry, that the matter will be going back to Dr. Johnston, who will formalize the terms of reference and the scope. Mr. Speaker, Dr. Johnston also issued an interim report in which he laid out some of his preliminary thinking based on what he had heard from the Ethics Committee witnesses up until about mid-December, December the 13th, I believe. Subsequent to this, Mr. Speaker, we heard from probably some of the more significant players within this matter. And, Mr. Speaker, I was prepared to start talking about some of the things that we found which would demonstrate why it was necessary not just to have a public inquiry, but in fact to have a formal public inquiry, Mr. Speaker, under the Public Inquiries Act, which gave you the opportunity to subpoena or the power to subpoena. That is a very essential element, Mr. Speaker, because we in fact found in our proceedings that there were witnesses who were reluctant to appear. And in fact, Mr. Speaker, the committee granted to the chair, myself, the authorization at my discretion to subpoena any witness at any time. So, Mr. Speaker, the committee was very aware of the problems that we were having with witnesses, and indeed it was a situation even with the former Prime Minister, Brian Mulroney, who in fact had declined our offer to come back for a second appearance so that he could answer the questions. Mr. Speaker, that was so serious that in his initial appearance before the committee on December the 13th, he was asked and agreed to provide certain information related to what did he do to receive, for the monies that he received from Karl-Heinz Schreiber. Mr. Speaker,
Mr. Mulroney had indicated that this had to do with international business, not with domestic affairs, nothing related to the government. He also indicated that he visited China, Russia, France. He had planned to go to the United States and even to have a meeting with the Secretary General of the United Nations to, in fact, promote light armored vehicles built by Thyssen Industries. Mr. Speaker, after 2 months of waiting and asking and reminding, there was still no response from the former Prime Minister as to who he met with, the dates, the locations, what the outcome was, Mr. Speaker. These were vital pieces of information because if the activities were not international, i.e. they were then domestic and maybe related to government contracts or other items such as Bearhead Industries, Mr. Speaker, that would have put the Prime Minister in a situation that he would have been in violation of Section 41 of the Parliament of Canada Act related to influence peddling. So, Mr. Speaker, this was very important, and as a consequence, the committee authorized me as the chair to issue a summons, Mr. Speaker, for that information to be provided within a certain date before our hearings resumed. Well, Mr. Speaker, that summons was not respected by Mr. Mulroney. He refused to answer, and in fact, the message from his lawyer was to the effect that this was private matters and it was none of the business of the committee. So, Mr. Speaker, if you take those two considerations alone, failure to honour a summons from the committee that has the right to call for persons, papers and records, as well as not being willing to come forward to give testimony when there were clearly ample questions to ask of Mr. Mulroney after we had heard from 10 other witnesses. This, Mr. Speaker, in my view, is a very important consideration to take into account when determining the form of the public inquiry. Should it be a formal public inquiry under the Public Inquiries Act? Should it be informal and simply under the Inquiries Act alone where they don't have subpoena power? Or should it be somehow a limited or maybe even no inquiry whatsoever? Well, Mr. Speaker, it is extremely important that questions be answered because when the people will look at the evidence that has been presented to the committee, which is on the official website of the Standing Committee, Mr. Speaker, it is a litany of contradictions, of discrepancies, of disputes of information. Mr. Speaker, I can't think of any issue on there that people actually agreed upon. There was contradictions on almost every point raised. The committee, Mr. Speaker, could have called more witnesses, could have tried to collaborate this information, and to find out who was not being truthful with the committee. It would then have had the option to deal with this matter by dealing directly with the House and recommending that certain persons be considered to be found in contempt of Parliament, Mr. Speaker, for having misled or lied to a committee. That was an option. However, Mr. Speaker, in the environment that we have come through, it was very clear that the committee was not going to be able to have the time nor the resources or the expertise to be able to call the necessary witnesses, to call for banking records, tax returns, Mr. Speaker, to call expert witnesses, forensic accountants and the like. Mr. Speaker, those kind of activities are best done, obviously, in a public inquiry. And as a consequence, the committee decided to, instead of consider the list, a preliminary list of some 40 witnesses, it was reduced down to 12 witnesses, Mr. Speaker, to give us an idea from some of the principal witnesses of the dimensions of what was going on and why. Now, Mr. Speaker, I don't believe for a moment that this matter is simply to do with whether or not Mr. Mulroney received $225,000 or $300,000. That amount of money is inconsequential when you consider the relationship between Mr. Schreiber and Mr. Mulroney, which goes back some 20 years. Mr. Speaker, 25 years. In fact, Mr. Mulroney and Mr. Schreiber were meeting even before he became the leader of the Conservative Party, when he was still a lawyer with Ogilvy Renault. They were having coffees already back in the early 80s. Mr. Speaker, that relationship grew, and in fact, Mr. Schreiber was involved with with persons to, in fact, dump the former Prime Minister, Joe Clark. They were also involved, Mr. Schreiber is also involved, Mr. Speaker, with the getting the leadership of the Conservative Party for Mr. Mulroney. This is the way that Mr. Schreiber does business. It was clear. It's clear from, as an example, he was involved with the Saudi government, a $440 million project to sell tanks to the Saudis, Mr. Speaker, some special tanks made by Thiessen Industries. About half of that money, Mr. Speaker, was grease money. It was bribe money for officials. And in fact, when you look at that particular case, you will find that a number of senior government officials, in fact, were prosecuted and found guilty. Guilty, Mr. Speaker, of influence peddling, bribery, etc. So, Mr. Speaker, this is the pattern. This is how it is done. Mr. Schreiber clearly was establishing a close relationship with virtually everybody in the Conservative Party that he possibly could. It was not only federal, it was also provincial. There was a lot of activity going on in Alberta. And at that time, the members will know that there are some people who got involved in some activities which turned out to be bad, and there was a lot of bad blood. Some deals just went bad. But, you know, Mr. Speaker, when you consider some of the activities that went on, to have the former Prime Minister, who's in Davos, Switzerland, to take a limousine ride for 2 hours to Zurich, to have lunch with Mr. Schreiber, and then go back to Davos, you have to get the sense that somehow maybe this is a pretty serious relationship, Mr. Speaker. And then you get the situation where Mr. Mulroney sues the Government of Canada for $50 million. Ultimately, Senate settles for $2.1 million. But, Mr. Speaker, during his examination for discovery under oath, and this is very puzzling, he was asked about his relationship and did he ever do any business, get any money from Mr. Schreiber? Well, Mr. Speaker, his answer was, I barely knew the guy, maybe had a coffee or two. This is in 2005. Well, Mr. Speaker, we know now that Mr. Mulroney had accepted, he says, $75,000 when he stepped down as Prime Minister, but was still a member of Parliament. This was in August of '93. And Mr. Speaker, subsequently received at the Queen Elizabeth Hotel another $75,000, he says, and in the Pierre Hotel in New York, another $75,000. And you have to ask yourself, why? Well, Mr. Schreiber says he was helping us with the Bearhead project. We wanted to promote light armored vehicles. We wanted to build this plant in Cape Breton. It was going to create jobs. So all of a sudden, people started to get involved, and many people were asked about this. And I found it very interesting to note that in Dr. Johnston's report, he considered matters such as Airbus and the Eurocopter case and Bearhead case to be well-tilled ground, Mr. Speaker, and therefore, I'm sorry, this is a 20-minute spot, Mr. Speaker? Thank you. So, Mr. Speaker, maybe you could advise me how much time I do have left.
There is 8 minutes left on the clock. Just my clock shows 0.
Okay. So, Mr. Speaker, there were a number of things going on. But it's very interesting to note that when you look at some of the testimony from the committee, you will find some of the matters indicate that the monies involved here were much greater. For instance, there is well documented in evidence tabled with the committee that an employee of the at 24 Sussex was in fact asked to go to the Prime Minister's office to see Mr. Fred Doucette. And he would pick up from Mr. Doucette envelopes of cash every week in the range of $10,000, $11,000. And where did this cash come from, Mr. Speaker? Well, as it turns out, some of it was coming in checks from the PC Canada Fund to the Chief of Staff, Mr. Doucette at the time, as in a check form. Mr. Doucette would cash the check and put the cash in an envelope to give to this employee to take to 24 Sussex, apparently to give to Mrs. Mulroney. And you have to ask yourself the question, why, Mr. Speaker, didn't the check from PC Canada Fund or whoever simply get sent to Mrs. Mulroney? Why is it that an employee had to go over to the PMO to pick this up? And interesting enough, this employee who appeared before the committee denied that he did this. And yet another employee was occasionally asked to go and get the money when the chef wasn't available. There are people who witness this in the PMO. There are people in 24 Sussex that will testify. There are people who have this, who had interviewed this employee and have written transcripts of these conversations. There's no question, Mr. Speaker, this particular person was not truthful with for the committee, and we're not sure why. But there is a reason. But the amount of money involved, Mr. Speaker, is much more. In fact, when we had some of our, we found that about $20 million was made available with regard to the Airbus industry affair. Mr. Speaker, half of that was going to Canadian persons. None of our evidence was able to determine or to identify who got that money. But we did find some of the money, Mr. Speaker, and it was clear where it was going to. Now, I could spend a lot of time tantalizing you, Mr. Speaker, but I found it kind of interesting that things didn't come out, and it's because there was not much time. One of the issues was about a gentleman, his name is Bruce Verchere, V-E-R-C-H-E-R-E. And, Mr. Speaker, the committee really didn't do anything with regard to Mr. Verchere, but he seems to be a key player. Mr. Speaker, Mr. Verchere was, in fact, the manager of Mr. Mulroney's blind trust while he was the Prime Minister. And Mr. Verchere, his background would show he had developed a skill in hiding money, and that he was involved with Panamanian shell companies and other offshore entities, and monies would land up ultimately in 2 banks in Geneva, both specializing in wealth management and in infinite discretion.
What a mess.
An expert in hiding money, Mr. Speaker. We haven't even looked at this. I don't know whether the RCMP ever looked at this, but you know what, Mr. Speaker? It's going to be difficult. There is some evidence, but in not too long after the Mulroney Airbus settlement, in August, I believe, of '96, Mr. Verchere walked into his bathroom, put a shotgun to his mouth, and blew his head off. So, Mr. Speaker, you know, these things have happened. Now, Mr. Schreiber also testified in the early 1990s that Mr. Doucette asked him to send a portion of the secret commissions from the 1988 Airbus sale to Air Canada to Mr. Mulroney's lawyer in Geneva. Mr. Doucette denied the claim, calling it a fabrication. But Mr. Schreiber went on and he told the committee that the Geneva lawyer was, in fact, Bruce Verchere. That was the lawyer. He may not, Mr. Mulroney may have been correct, saying it never had a lawyer in Geneva. He was from Montreal. He just happened to have accounts there. So, Mr. Speaker, you can see how this gets. All I can suggest, Mr. Speaker, is there are more questions than there are answers. And today in the Globe and Mail, Mr. Speaker, absolutely an astounding story that was published in today's Globe is a story, in fact, an interview with Senator Lowell Murray. He was the first minister to head up ACOA when it was started, the Canada Opportunities Agency. And, Mr. Speaker, the day he was appointed, Mr. Mulroney gave him a file. What was the file on? Bearhead Industries, to build this plant in Cape Breton to do these Thyssen vehicles. This is the plant and the project that the RCMP included in its list of well-tilled ground. This has just come out today, Mr. Speaker. We have brand new evidence, and in fact, when you look at some of it, it was clear that this was a proposal that was important to Mr. Mulroney. And he goes on, and there's some great information. But, Mr. Speaker, I don't have the time to go through it. But suffice it to say, when things happen, for instance, like Mr. Fred Doucette, who's working for the government, for the Prime Minister, and all of a sudden, after the Airbus contract is awarded, he then leaves government, and within 3 months, on November the 2nd, 1988, he bills Karl-Heinz Schreiber $90,000 for professional services. Frank Moores of GCI, also, same dates, bills $90,000 to Karl-Heinz Schreiber. Gary Willett of GCI also bills $90,000 to Mr. Schreiber. And Jerry Doucette, Fred Doucette's brother, also bills $90,000 for services. Then GCI as an organization, a lobby firm who was the linchpin in all of these activities, Mr. Speaker, bills on the same date $250,000. That's $610,000 just a few months, 3 months or so after the Airbus contract was awarded. And paid, Mr. Speaker, on November the 15th, just days before the 1988 election was called. Mr. Speaker, these are not coincidences. It is not a coincidence that there is no paper trail, that cash was used, that $1,000 bills were appearing everywhere. They described it as falling from the trees. Mr. Speaker, when you get an honourable senator who knows nothing about what's going on, says that these things were happening, it was clear Mr. Fred Doucette was totally involved, even though he told the committee he had no involvement with Bearhead. Senator Murray has now shown that Mr. Doucette was not truthful with the committee. Mr. Speaker, all this being said, I have to only conclude, Mr. Speaker, that the circumstances we are now passing over to Dr. Johnston and to the public inquiry must be dealt with by a formal public inquiry under the Public Inquiries Act, Mr. Speaker, with subpoena powers, because it's very clear the people who are now engaged in this have been caught in lies and mistruths, have been shown contempt to Parliament. Mr. Speaker, do not hold, I don't believe we should hold a new commissioner tie his hands in any way. He should have an opportunity to be involved in determining the scope in terms of reference and be able to follow the money.
Absolutely.
Questions and comments? Questions et commentaires. The honourable member for Blackstrap.
Mr. Speaker, I seek unanimous consent to table the following documents: the government's response to question 161, Q183, Q184, and Q189.
The honourable member for Blackstrap is raising a point of order. The
Does the honourable member have the unanimous consent to put the motion?
The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? The honourable member for Blackstrap may deposit these documents.
All right.
Questions and comments? Questions et commentaires.
Questions and comments.
Member for Winnipeg Centre.
Thank you, Mr. Speaker. And I want to thank my colleague, the chair of the Standing Committee on Access to Information, Privacy and Ethics, for moving concurrence on the report from our committee today. As I remember it, it was a very straightforward and simple report. It simply announced to the House of Commons that our committee had concluded the witness phase of the study into the Airbus Mulroney-Schreiber scandal as it's come to be known. And I want to thank first my colleague, the member from Mississauga, for the work that he's done on that committee and for having the fortitude and the wisdom that it takes to be a good chair juggling a very difficult issue of national importance and interest to the whole country. I think he's done a great service to Canadians by keeping an even keel on this study and making sure that it's moved forward to its logical conclusion. I would like to remark on a few of the points that he made. First of all, there is no excuse anymore for the Government of Canada to postpone the full public inquiry that this report calls for. The Prime Minister said he didn't want to begin the public inquiry because there might be overlap between witnesses that the Ethics Committee calls and witnesses that the public inquiry calls. Well, we're finished with witnesses. We've announced that formally, and our chair stood in the House of Commons and made a public declaration. We're done. So there's really no excuse and no reason. May I also say that there's no excuse for the Government of Canada to announce a very narrow public inquiry because limited perhaps, for instance, to just the cash payments given in hotel rooms to the former Prime Minister, because as recently as today, as my colleague points out, this ground that Dr. Johnston said has been well tilled and adequately researched is still revealing new truths. Just today, a senator in the current Parliament of Canada has revealed how important that Bearhead file was to the former Prime Minister Mulroney, and how it was key and paramount, the very first file given to him in the newly struck ACOA portfolio that he was given. So let me simply ask my colleague the question. It's my view that no amount of baffle-gab will ever take the stink off of those sacks full of cash in secret hotel room meetings. There is no amount of excuses that the former Prime Minister can offer Canadians to defend that. But let me ask him if it's not just as important that we go beyond the sacks full of cash and research the genesis of the scandal, which is Karl-Heinz Schreiber, an unrepentant Nazi, is what the German media calls him, interfering with Canadian politics by buying our next Prime Minister. That's shocking. The CEO of Airbus, creating a Prime Minister and then having that Prime Minister buy airplanes from him. If that's not worth investigating, Mr. Speaker, I don't know what is.
Honourable member for Mississauga South.
Mr. Speaker, I don't disagree with the points made by the member. We are going to have a public inquiry. The issue really is what form will it take? And in his preliminary report, Dr. Johnson had given maybe a range or a menu of options. Now that we've heard more witnesses than he had heard previously, I think that he may want to reconsider at least one of the points, and that is that the RCMP did a thorough, effective investigation of the facts. But you know, Mr. Speaker, take one example. In his testimony on examination for discovery, Mr. Mulroney said that he barely knew Mr. Schreiber, he had a coffee or two, when in fact if the RCMP had done a thorough investigation, and it says even in Dr. Johnson's report that the RCMP had knowledge of the cash payments, why didn't the RCMP advise the Government of Canada at those proceedings in 2005 that Mr. Mulroney just lied in his discovery?
Good question.
Why not? I mean, Mr. Speaker, doesn't the RCMP support the Government of Canada in its legal proceedings? Mr. Speaker, this was a $50 million lawsuit. Mr. Speaker, there was perjury there. The Canadians are entitled to have that matter to be reconsidered, and in fact, the former Justice Minister of the day appeared before us and said, had he known those payments were made, Mr. Speaker, that would have changed the way they approached that case. Canadians probably would have not had to pay that money. So, Mr. Speaker, I think that there has been a presumption somehow that the RCMP has done a very good job, and let's just assume everything that they've concluded. I don't think that that's a valid conclusion, Mr. Speaker. Errors were made, the ball was dropped, Mr. Speaker, and new evidence has shown that even with regard to Senator Murray's his testimony, as it were, through the media today in the Globe and Mail is very clear. This is brand new evidence, and in fact brings into question the credibility of yet another witness that appeared before our committee to say that he knew nothing about, had no involvement. And yet this is the same person that was sitting in the Pierre Hotel with Brian Mulroney and Karl-Heinz Schreiber when Mr. Mulroney apparently gave a 1 to 1.5 hour report to Mr. Schreiber about his international work, which Mr. Schreiber says never happened. You know, Mr. Speaker, when you ask Mr. Doucette, does he know who the Prime Minister met with in China, for instance? It's a pretty big country.
Absolutely.
He says he has no recollection. Okay? Those are the kinds of situations that a public inquiry, a formal public inquiry, is going to have to deal with, Mr. Speaker. There are people who have lied to the committee, have lied to Canadians. Mr. Speaker, the testimony is in contradiction almost at every spot. It is very clear, Mr. Speaker, that to do this properly, to resolve it once and for all, we need a commissioner who is involved in determining the scope in terms of reference. We need to make sure that the Commission has the powers to call for persons, papers, and records by subpoena. And, Mr. Speaker, also that this Commissioner have the full latitude and confidence that he will not go anywhere except where the evidence leads him, material evidence leads him to determine the truth and nothing but the truth.
Questions and comments? Questions et commentaires? The honourable member for Ottawa South might want to look at the chair as he formulates his question.
Thank you very much, Mr. Speaker. I am, as a member of Parliament in this House, shocked for what I have heard here from my colleague, the chair of the Standing Committee. It is more than disturbing, And to paraphrase Mr. Mulroney himself in a question to my colleague, the government here, sir, has an option. It has an option, Mr. Speaker, and that is to proceed in an open, transparent way. And I'd like to hear more from my colleague, more information, more shocking revelations, as we've heard from the Senator today. I'd like to hear more from him to substantiate his call for a fully open, funded, properly empowered inquiry to get to the bottom of this, because I think it speaks directly to the whole question of the office of the Prime Minister, whether it has been brought into disrepute, sullied, what exactly happened here. I really need to know more. I think Canadians deserve to know more as well. Perhaps I could put that question to my colleague, Mr. Speaker.
The honourable member from Mississauga South has a minute and a half to rant.
Thank you, Mr. Speaker. You know, Mr. Speaker, when we asked for records, there were no records. When we asked for banking documents, we had trouble getting them. Mr. Speaker, the RCMP did investigations over a long period of time. When we asked them to share the information that they had from their closed investigations, it was denied to us. Why, Mr. Speaker? Because they said the inquiry, the investigation may be reopened. Who is saying this to the RCMP? What information do they have, Mr. Speaker? The RCMP has more information. There's more developments. They're doing further reviews. Mr. Speaker, the details continue to come out. I would think that when you consider some of the other facts, if I could throw them in, 13 of the 15 members of the Board of Directors of Air Canada, then a Crown Corporation, were fired and replaced by Mr. Mulroney before the Airbus award the contract. And, Mr. Speaker, it's interesting to note that the President and CEO of Air Canada at the time, after the Airbus settlement or the Airbus contract was awarded, and he retired. Where did he retire, Mr. Speaker? Toulouse, France, which happens to be the headquarters of Airbus Industries. You know, Mr. Speaker, when you look at some of the details, you will say, why this looks like everything that we touched looked like an impropriety. But the conclusion continued to be reached by people, there's no evidence. Well, Mr. Speaker, it's clear that there is substantial evidence that the inquiry must look, a full public inquiry should look into, and I hope that we proceed.
With regret that I must interrupt the honourable member. Resuming debate, the Parliamentary Secretary to the Minister of Intergovernmental Affairs and Minister for Western Economic Diversification.
Well, thank you, Mr. Chair. I appreciate this opportunity to address this House on this subject. It comes as a bit of a surprise that we're even having this discussion, because I don't think anybody expected concurrence in this particular motion, since the motion that we're here to debate is an extraordinarily small motion. In fact, it's quite unique, I think, in this chamber that we're having this debate at all. Just to give you a bit of background, Mr. Speaker, our committee began this investigation into this matter last November after some spurious allegations were printed in the paper, and at that point the Prime Minister indicated that he was going to appoint somebody to investigate this matter. He subsequently hired Professor Johnston to take a look at this issue and provide a report to the government that was later tabled in January. But not satisfied with the steps that the government was taking.
I'm sorry to interrupt the Honourable Parliamentary Secretary. L'honorable député de Hull.
The Honourable Member for Hull-Aylmer on a point of order. Thank you, Mr. Speaker. I would appreciate it if you could check whether we have a quorum in the House right now before we continue. Thank you.
Je me lève là puis je compte. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Je remercie l'honorable député.
I thank the Honourable Member for Hull-Aylmer. We do have a quorum in the chamber.
The Secretary has the floor to continue with his statement.
Thank you, Mr. Chair. I appreciate the member's vigilance as he leaves the chamber, and the opposition is now vacant. Quite ironic that they're calling for quorum when their own members aren't even present.
The Honourable the Parliamentary Secretary knows full well, as I explained yesterday, that we do not point out to the absence or presence of members of the House. He may continue with his statement.
I apologize for that, Mr. Speaker. It just seems ironic that the opposition is calling for a quorum call at this particular moment. Anyway, I was saying before I was interrupted that providing some background as to how we got to this place. The Prime Minister had, in fact, asked for Professor Johnston to provide a preliminary report, but before Professor Johnston could complete his work, the opposition took it upon themselves to force this matter onto the Ethics Committee. The Ethics Committee had other issues that it was in the process of investigating. In fact, we had put forward some issues related to the Privacy Act that needed to be addressed urgently. But all of these matters were set aside because of this matter that had come before the media and come before Parliament. So seized with this new opportunity to investigate a 15-year-old incident, the committee took upon itself the obligation of requesting witnesses, and our first witness, of course, was Mr. Schreiber. We heard from Mr. Schreiber, I think, on 4 occasions for a total of 8 hours initially. He later came back and provided us additional testimony. And then we heard from Mr. Mulroney, but then we heard from a number of other witnesses. I want to note, Mr. Speaker, that throughout this entire time, at least certainly at the end of which we heard from Mr. Schreiber, it was apparent to government members that there was no evidence of wrongdoing, certainly at that point. Now, the member opposite has stated just a moment ago that he's clear that there was substantial evidence of wrongdoing. In fact, he's declared that a number of the witnesses, without naming those witnesses, actually lied to the committee. And I find that quite a surprising statement coming from the chair when he himself had the opportunity to confront those witnesses if he had so chosen to do so when they were before our committee. But needless to say, based on the testimony that we heard, we reviewed the Parliament of Canada Act, we reviewed the Code of Conduct that applied at the time, and based on the testimony that we heard from Mr. Schreiber, there was no evidence of wrongdoing. But we entertained the opposition when they insisted on inviting, I think initially the number was close to 40 witnesses before the committee. They later pared that down. I need to note, Mr. Speaker, that as Conservative members, we did not ask for any particular witness. We didn't think it was appropriate to do so, but we listened to the witnesses that were provided by the opposition. And again, we went through this scenario of every Tuesday and every Thursday for 2 hours, or sometimes double appointments on some meetings. We heard from witnesses come before the committee and offer what they knew about this Mulroney-Schreiber affair. But in not one instance did anybody offer anything of substance in terms of ethical wrongdoing. And the reason I can say that with such certainty is because with every witness that came before our committee, I or one of my colleagues dutifully asked them the question, was there any evidence, did they have any evidence of any wrongdoing by any public official related to this matter? And not one of these witnesses provided such evidence. In fact, not one of them could even refer to such evidence existing, whether or not they knew it or not. Each one of them, given the opportunity to clarify for Canadians whether or not they knew of evidence of wrongdoing, dismissed the question or denied they had any evidence. But again, the committee persisted, and we continued to listen with at least on my part, with some hesitation, because I was always fearful, and in fact said from the very beginning that I thought that this was simply going to turn into a political partisan witch hunt, which at times it certainly did, and at other times it appeared to be a bit of a political circus. Now, this continues. We hear from all these witnesses. Mr. Schreiber comes back at the end of all these witnesses and has nothing new to offer, despite his claims to the media that he has new documents that hadn't been released. But we get to the point where we've heard from all the witnesses, and the committee now has to decide whether it's going to call, Mr. Speaker, more witnesses, or whether we're going to call it a day and try and summarize our evidence. At that point, the committee has a discussion, and we decide that, okay, enough's enough. We're not going to call any more witnesses. We think at least the opposition admits that they've dragged this on long enough, and we notify the witnesses and we notify this chamber that, that no more witnesses will be needed and that we're going to summarize the evidence. So the committee agrees to the third report of the Ethics Committee. I'll just read it out here briefly for you. It is very brief, so it will just take a minute, but it says that the Standing Committee on Access to Information, Privacy and Ethics has the honor to present its third report. Your committee met on Thursday, February 28, 2008, to discuss the Mulroney Airbus settlement and agreed to the following recommendation. As your committee has now completed its examination of witnesses in this matter, it recommends, as it did in its second report to the House, that the government immediately initiate a formal public inquiry into the Mulroney-Shriver affair. And then it goes on to give some details of minutes tabled and that sort of thing. Well, this is the motion that we're now debating before this chamber. I find this quite ironic because this motion, concurrence in this motion, is simply that. We're simply acknowledging that no more witnesses are going to be called, and that the silence behind this motion basically indicates that we're going to be putting together a report. And in fact, Mr. Speaker, that's exactly what we're doing right now. We're taking the time to summarize the testimony that we heard from the witnesses, to compile the thousands of pages of documents that were submitted to our committee, and we're putting them together so that we can fulfill our responsibilities as members of this committee and provide this chamber with a summary, or a conclusion, or recommendations of what we've heard in the 4 months of testimony that we had. So why we're now debating this particular motion, I think, is rather ironic and perhaps unique to this chamber. Perhaps the Speaker, you yourself, might know how often in the history of this chamber such a limited non-motion or non-report has been discussed. But anyway, that's where we find ourselves. I just want to make a few more comments on why I think it's inappropriate for this committee to, at this point, even pretend that we have a report to discuss. Mr. Speaker, we've begun to consider a draft report. It's many pages in length, simply summarizing the issues that we've heard. And as I've said earlier, there's none of it that has any evidence of wrongdoing. But for this committee, or for this government, for the opposition, I should say, to press this chamber to consider this issue, as they did 2 weeks ago, is, I think, a bit misplaced. And let me explain why. 2 weeks ago, we had an Opposition Day motion in this House where we debated whether or not the government should proceed with the public inquiry immediately. And at that time, I argued, very strongly that because this committee hadn't finished its work, it would be improper for us to do so. Well, here we are again. I mean, this feels a little bit like Groundhog Day, where we're coming back to an issue that's already been addressed some weeks ago. The bottom line is, Mr. Speaker, that Professor Johnston has a mandate to provide recommendations to the Prime Minister as to the scope of a public inquiry. That's what the Prime Minister hired him to do, and he's partially completed his responsibilities by providing an interim report in January, but he cannot complete his report until he's seen the report that our committee is supposed to provide him. We're in the process of working on that report. It's nowhere near completion, but we do hope that in the next couple of weeks we will be able to complete it. But it's a bit nonsensical for the member opposite to suggest that the government proceed immediately to a public inquiry when they don't have the benefit of what our committee has put its hand to for the last 4 or 5 months. We've heard 25 to 30 hours of testimony from well more than a dozen witnesses, and it would be improper for the government or even Professor Johnston to recommend to the government the parameters of a possible public inquiry without the benefit of hearing from our committee. Again, our job as committee members is not simply to listen to testimony and say, okay, enough's enough, you guys go off and do the rest of the job for us. We have to finish our work, and for us to finish our work means that we have to compile the testimony, we have to debate whether or not there's recommendations that this committee should make to the House, and perhaps there's some conclusions that we can draw to. Now, I'm personally quite skeptical as to whether or not there are any recommendations that we can make in light of the fact that there was no evidence of wrongdoing, and I'm also skeptical of the fact that we may not have any conclusions that we can provide for the very same reason. Nonetheless, the committee has an obligation to fulfill its responsibilities, finish its work, and that will hopefully be done in the very near future. But for the member opposite, or for the party opposite, to suggest twice within 2 week period of time that it's imperative that the government proceed with this in public inquiry before they've had the benefit of our report is a little bit nonsensical. And I would ask them to perhaps put more forethought into their use of the time that this chamber focuses on in the future. But nonetheless, we're here debating this issue. I think it's a bit hasty to suggest that the government proceed with this without that further information, but that's their purview. Now, I simply want to draw your attention, Mr. Speaker, to some points that I made the last time we had this debate, because they are particularly relevant. And if you can just give me a moment here to find my spot. I remember telling this chamber about the mandate that was given to the independent advisor. I'm speaking of Professor Johnston. The mandate assigned to the independent advisor included 4 areas, and I'll read them for you. First of all, to conduct a review of the allegations concerning financial dealings between Mr. Schreiber and the Right Honourable Brian Mulroney. Second of all, to make recommendations as to the appropriate mandate for a full and public inquiry in these allegations, including the specific issues that warrant examination. Thirdly, to determine whether any prima facie evidence existed to suggest that criminal acts have taken place. And fourthly, to indicate whether any additional course of action was appropriate. Now, to fulfill this mandate, of course, as I mentioned, the Prime Minister hired Professor Johnston, who's a very reputable individual. He's the president of the University of Waterloo. In fact, he has impeccable credentials, which are widely admired because of his considerable legal experience and expertise. Now, it should be noted that during the course of his career, Professor Johnston has served on numerous provincial and federal task forces and committees. So he's therefore perfectly suited to fulfill this responsibility. But nevertheless, I think it's improper for us to expect Professor Johnston to fulfill or to complete these responsibilities until he's had a chance to see our final report. So again, here we have it. We have the opposition simply trying to hold to manipulate the process when it's obvious to everybody who's been following this issue that that's not necessary. I think we're all confident that once our report is complete and Professor Johnston has had a chance to review our ethics report, that he will make the recommendations that he chooses to make to the Prime Minister. At that point, the Prime Minister will look at those recommendations and make a wise decision, as he always does. But I think at this time, I've said that all that's necessary to be said on this particular topic, and I thank you for your rapt attention.
Questions and comments? Questions et commentaires. L'honorable député.
The Honourable Member for Saint-Bruno, Saint-Hubert has a question for the Honourable Parliamentary Secretary. Yes, she has the floor. Mr. Speaker, I do have a question for the member for South Surrey. He spoke earlier saying that it was like Groundhog Day, and I agree with him because it is just like in the movie. When people do not have an honest, responsible attitude, when people do not understand how to act properly, then it is a bit like a Groundhog Day, and the same thing happens over and over again every day. And this is what's going to happen to the member for South Surrey. On January the 11th, his leader, the Prime Minister, said that the Public Inquiry Commission would be set up as soon as the public hearings were finished. He said that. And the member is saying, no, it is when we have the final report. So I want to ask him, when we have that final report introduced, will he again contradict his leader and set up a new deadline or a new obstacle to the public inquiry? The Honourable Parliamentary Secretary.
Well, thank you, Mr. Speaker. It's interesting that this member asks this question, because if I recall correctly, this was the same question that she asked about 2 weeks ago when I spoke to this matter as well. She misrepresents the facts. She's suggesting that the government made a commitment that the government did not make. The government made a commitment to address this matter at the appropriate time based on the recommendations of Professor Johnston. Professor Johnston, his mandate is clear. I spoke to it a moment ago, and his obligation to this House and to this, actually to the Prime Minister, not to this chamber, is to provide some recommendations as to the scope of an appropriate mandate for a public inquiry. At no time did the government or the Prime Minister say that as soon as the committee has completed its listening to witnesses, that they would proceed with the public inquiry. What the Prime Minister said, and this was affirmed by Professor Johnston, is that once the committee had completed its work, or words to that effect. Now, our work is not done until we submit a report to this chamber. To suggest otherwise is actually a bit offensive to the members who serve on the numerous committees in this House, because it's not simply our job to listen to witnesses and then once they're finished speaking to say, okay, our work is done. No, that's not the case at all, Mr. Speaker. Our obligation is to listen to the witnesses, to synthesize and to consider the testimony that we've heard, to take the time, once the witnesses have all departed the chamber, to take some time to summarize the testimony that we heard. Thankfully, with the able assistance of so many of the researchers on these committees, they're able to help us with a draft of the testimony, summarizing the key issues. And then once that's all considered, and we've had a chance to look at that, we put our minds to recommendations or to conclusions that we heard, things that we can share with the government based on our newfound expertise in a particular subject matter that this chamber and that this government can benefit from. Here the member opposite is suggesting that no, we shouldn't take the time to do any of that, that because we've finished hearing from witnesses, that the government should immediately proceed with a public inquiry. Well, that's a little bit irresponsible, Mr. Speaker. She's suggesting that her own contribution to a report would not be worth reading or worth listening to. And I think that's an offense not only to me, but to her own contributions on this committee. She diligently works on other reports that are currently before our committee. In fact, she puts forward numerous motions and numerous recommendations and numerous amendments to the draft documents that we've considered from previous studies that we've done. Yet here, she inconsistently now suggests that the contributions that she's making in one study shouldn't be considered in another area study. And I think that's actually quite hypocritical for the member opposite to think that her contribution in the area of the Afghanistan report that we're currently working on are worthwhile and deserve the time to diligently make amendments word by word throughout the document. But now on this other study, she has nothing to add, and in fact she's making the assertion that no member should have an opportunity to review a report or to make edits or recommendations to a report. So I think it's a bit hypocritical and ironic that this member is making such a statement.
Questions and comments? Questions et commentaires. The honourable member for Scarborough Rouge River.
Scarborough Guildwood. It's a better file and better riding than Scarborough Guildwood. That's true, Mr. Speaker, but not exceedingly better. Certainly, it's one or two. It's two or one or two. Either way. I was wanting to ask the honourable member for his comments on the Globe and Mail article in this morning's Globe. How one file set off Schreiber's string of mystery payments. Mulroney's Atlantic Minister speaks out on proposed arms plant. And I wanted to connect that to the rather curious statement by the honourable member that really we've done everything that we can possibly do at the committee and there's really no more questions to be answered. Where the article goes to say, Mr. Murray said he couldn't recall speaking about the factory with Mr. Ouellette. Mr. Murray is Senator Lowell Murray, the one of three progressive conservatives in the remaining in the chamber. And he said he had a vague recollection of meeting with Mr. Moores, who was the former Premier of Newfoundland, but he said he couldn't remember the exact date. Fred Doucette's only public comments about this role came with Bearhead Project came in February when he testified before the House Commons Ethics Committee. In sworn testimony, the former Mulroney staffer was asked when he started working for Mr. Schreiber. His answer, I believe I got on the payroll of February of 90, was 14 months after he issued his $90,000 invoice to Mr. Schreiber. When the contradiction was exposed in the media, Mr. Doucette's lawyer sent a letter to the committee apologizing and explaining that his client was mistaken, but neglected to explain how Mr. Doucette came to make that mistake. Questions about what Mr. Mulroney knew about the commission deal and why he selected the Thiessen file as the only file to hand Mr. Murray that day during his first day on the job remain unanswered. The public relations firm handling inquiries to the former Prime Minister declined to comment. In December, Mr. Mulroney testified before the House of Commons Ethics Committee that he was supportive of the project, but was never asked about the money that was funneled back to Canada. I'm therefore a little bit surprised that the honourable member seems to have no interest in speaking to Senator Murray at the committee, or Mr. Doucette, or Mr. Doucette's public relations firms, or Mr. Mulroney's public relations firms, or Mr. Mulroney's lawyers, or Mr. Mulroney again. It seems to me that the honourable member would prefer to know much less about this file than more. So I'd be interested in his comments on this Globe and Mail article, which is really quite an extensive article, Mr. Speaker.
The Honourable Parliamentary Secretary has the floor.
Thank you, Mr. Chair. Well, I will certainly respond to my colleague's question, although I regret that he hasn't had an opportunity to follow this matter as closely as perhaps he would have liked, because had he had that opportunity, he would know that it was the opposition, his party, in fact, that provided the list of witnesses, and so perhaps he should be asking his own colleagues on our committee why they didn't call, Senator Lowell Murray as a witness before our committee. In fact, they've called absolutely everybody else that could be considered, so why they didn't include Mr. Murray, I'm not so sure. In fact, they called so many witnesses, they stretched the bounds of credibility by even calling the former chef to 24 Sussex Drive, Mr. Francois Martin, who, unfortunately for him, was put in the spotlight with nothing to offer to this committee. He did offer his recipes, but they weren't really relevant to the study that we were taking upon ourselves at that time. But if he has a question as to why Senator Murray was not invited, perhaps he could call on his colleagues to ask that very question. Now, my colleague from the bloc earlier asked me, or made a statement that suggested that the Prime Minister was going to call a public inquiry immediately once our committee had finished his work. I want to read the quote that the Prime Minister, stated on January 11th that clarifies this matter. It states, "I have also asked Professor Johnston to finalize his recommendations on the terms of reference for the public inquiry on an expedited basis once the committee has completed its work. I'm pleased that he has agreed to do so." So there you have it, Mr. Speaker. Once the committee has completed its work, we'll be in a position to have Professor Johnston provide recommendations to this, to the Prime Minister. But we haven't completed our work yet. And as I've said earlier, our work will be done when we've tabled a report to this chamber that summarizes our testimony and perhaps includes some recommendations and conclusions. Thank you, Mr. Speaker.
Reprise du débat.
Resuming debate, the Honourable Member for Saint-Bruno, Saint-Hubert. Thank you very much, Mr. Speaker. In response to the member for South Surrey, my version says that on January 11th, the Prime Minister said that he will set up the public inquiry as soon as the committee has finished its work. But we have heard the response many times in this House that the reason the Prime Minister did not want to carry out the public inquiry before the committee finished its work was that there should not be the two processes underway at the same time. There, in fact, would be no danger there because setting up the public inquiry would take months. In fact, for the Gomery Commission, it took 6 or 7 months. So I think there is one pretext after the other being used to delay the public inquiry. It's the same thing as in the committees. A lot of work has gone into delaying the proceedings. The newspapers are asking if they don't have anything to hide, why are they doing everything to hide it? I do not have a great deal of time left because we will soon be out of time. So I will come directly to my conclusions, and then I will go back to the beginning of my arguments, the ones I wanted to make. The first argument that I heard, or rather the most recent one, was that the money provided by Mr. Schreiber to Mr. Mulroney was a private transaction, and there was no reason that parliamentarians, taxpayers, or the public should be involved in it. But, Mr. Speaker, when taxpayers learn that the former Prime Minister of Canada has received from the that are among the most powerful at the time, $200,000 or $300,000 in cash, and when people know that this lobbyist has had access to a great number of contracts and has earned $225 million in commissions, there were over $2 billion in contracts, and that this money went to everyone around the former Prime Minister, and that even before the Prime Minister left, he collected cash. Well, people in my riding, perhaps not those of the South Surrey riding, but certainly people in my ridings, necessarily think that this cash without any receipts has to be for work done while he was in office. This is not a private transaction we're talking about, and this is why we need to shed light on what happened. The honourable member for Mississauga said that there were a number of contradictions. There is a huge list of contradictions, in fact. Things, facts that do not match. There are loopholes and many things that we need to shed light on. Moreover, we need to shed light on the correspondence from the Prime Minister's office. We know that letters were sent to the Prime Minister by Mr. Schreiber to talk about things that happen, and certainly we looked into this a bit by the committee, but we need to shed light on all of this issue of correspondence. Why did Mr. Mulroney admit that he had done the wrong thing? He apologized profusely. But why did he make that error in judgment? Why did he accept so much cash from the most powerful lobbyist around his government? Why did he do that? What was he thinking? What were his motivations? This is something that we will have to ask. Brian Mulroney said that Mr. Schreiber always gave cash. Mr. Lalonde said this was not the case. In fact, on the contrary. And Mr. Lalonde said that there was no plan to sell tanks to China. The former Prime Minister said the opposite. There was nothing done to change or correct the perception that wrongdoing had taken place. He told us a whole long story made up of all sorts of bits and pieces. There was a contract. What contract, Mr. Speaker? The two parties do not agree on the nature of the contract. I've never seen anything like it. This is extraordinary. They don't agree on the amount of the contract. Obviously, one is right and one is wrong, but if there is $300,000 in question, there have to be documents. One of them said that the money was for work around the world, and the other said that it was for work in Canada. So the two versions are incredible. We also had the statement, the reporting of the income 5 years later by Mr. Mulroney. He started to worry that something might come out. Mr. Schreiber was starting to have legal problems, and his extradition looked imminent. So we have this situation where Mr. Mulroney and Mr. Schreiber are going to have to give solid evidence about what happened and where the $200,000 and some $1,000 or the $300,000 came from and went. Bribes were provided for this ongoing series of contracts obtained by Mr. Schreiber. Is that the case? Taxpayers have a right to know. taxes were used directly or indirectly to pay commissions to give contracts to powerful companies by that government. And we need to know whether these taxes went to pay for planes or helicopters or the other things that were involved in those Schreiber contracts. So all of the contracts involved between 84 and 2000, we're talking about over $2 billion in contracts and $225 million in commissions. So we absolutely need to have evidence before a public inquiry that needs to be set up as soon as possible with as broad a mandate as possible. Mr. Mulroney needs to appear before the inquiry and needs to do so under oath. I talked about the Mulroney-Schreiber contract, and this was treated as if there was something illegal going on. There were two versions, and they are not credible. Mr. Mulroney also said that he had permission from his cabinet to enter into contracts as a sideline. I know that this is not really the right expression, but I believe that it reflects what I mean here. He was asked why his legal office, his law office, allowed him to do this. He said that he was allowed to do it and that he would provide the contracts with his legal firm. But, Mr. Speaker, there was a sheet shown to us that showed a single clause. It was very vague. There was no evidence, in fact, that this practically empty page reflected a real contract between his legal firm and Brian Mulroney, and that clause was in effect at the time when Brian Mulroney accepted the money from Karl-Heinz Schreiber. The public inquiry needs to ask the legal firm where Brian Mulroney has been working for the real contract to look into whether that clause exists, to see whether it was in effect when Brian Mulroney accepted contracts, except other than those that were issued by the legal firm. Do I have any more time left, Mr. Speaker? I must now interrupt the proceedings on the motion. Accordingly, the debate is deferred to an upcoming session. When we come back to this debate, the honourable member for Saint-Bruno-Saint-Hubert will have 10 minutes. In addition, there will be 10 minutes for questions and answers.
The House will now proceed to the consideration of private members' business as listed on today's order paper. Orders of the day.
Private members' business.
M400, Women's Program at Status of Women Canada, standing in the name of Mrs. Barnes.
The honourable debate, the honourable member for Simcoe North.
Well, thank you, Mr. Speaker, and I am pleased to rise today in the debate on motion M400, which asks the Government of Canada to include equality in the mandate of the Women's Program of Status of Women Canada. As honourable members full well know, our government has already included the word equality in the mandate of the Women's Program at Status of Women Canada. I know some opposition members were surprised by this announcement, Mr. Speaker, when the minister appeared in committee, but it is the reality. Now, I have to admit that I don't really understand why we're still debating this motion when it has already been rendered obsolete. The word equality is, as I've said, included. You know, Mr. Speaker, back in committee, and I am on that standing committee, I recall a question on behalf of the member for, in fact, Beaches East York, put the question to the Minister of Heritage, Status of Women and Official Language languages during her appearance when she asked, "Are you saying that you've now changed the policy and you've put the word equality back in the mandate? That's what I understood you to say," end quote. The minister responded with the word, "Exactly, Mr. Speaker." Yet here we are debating a motion asking that the focus of the women's program be equality. So what does the opposition do? They change their minds. Through the shock and surprise of the minister's words at that committee, the opposition decided that what they really meant, Mr. Speaker, was to say that equality means advocacy and groups that receive funding for advocacy. Mr. Speaker, indeed, the raison d'etre of the Status of Women Canada is the goal of advancing the equality of women in Canadian society. As a country, Canada has a strong legal framework for protecting human rights, and this foundation has provided a fertile ground for promoting equality, including the equality for women. The Women's Program at Status of Women Canada reflects this legal foundation. It focuses on promoting the equality and full participation of women in the economic, social, and democratic life of Canada. Equality for women and their full participation are not only important for women, their families, and their communities, but also for the country. In the future, to ensure Canada remains one of the most prosperous countries in the world, we must increase the participation of women in the workforce and fully support their career choices. Canada's population is aging. During the next 2 decades, it's predicted that the ratio of older persons to active workers in Canada will increase by some 20%. Most of those people will be women. More than ever, we will need strong women leaders to keep our country strong, economically, socially, and as a democracy. Having more women in the labor force, including older women, will fuel economic growth and productivity gains in the long term, and that benefits all Canadians. It's because our government remains committed to equality that we fully support this motion. But actions speak louder than words, and in December 2007, our government amended the terms and conditions of the Women's Program at Status of Women Canada to include equality. In support of this noble goal, the Women's Program provides financial and professional assistance to organizations. Organizations, in turn, carry out vital projects that improve women's lives at the local, regional, and national levels. The projects selected for funding focus on key areas such as women's economic status, violence against women and girls, and all of this within an accountable and transparent framework. Strengthening the Women's Program at Status of Women Canada is just one of our government's impressive list of accomplishments that are improving the lives of women across this land. Included in this list is this government's increase in the Women's Program budget to $20 million, an increase of 76%, the highest level ever, Mr. Speaker. This is proof positive of both of our confidence in the program's work and of our commitment to achieving results for women. With the creation of 2 new funding components, the Women's Program is poised to continue to achieve results for women directly in their respective communities throughout the country. As a result of the first call for proposals, which took place in June of 2007, $8 million in funding has been distributed to 60 projects across the country through the Women's Program. Over 260,000 women and girls will benefit from these projects. They'll be addressing everything from the barriers they face, helping to teach them about violence prevention, educating them on how to achieve better financial literacy, and encouraging cooperation and peer support networks. The second call for proposals took place in November of last year for the Women's Community Fund. There we received a record number of proposals with a total of 342 proposed projects. 107 projects have been accepted and will best achieve results for women by promoting women's economic security and prosperity, health and safety, and ending all forms of discrimination and violence against women. With the newly added convenience of online application forms, the Women's Program can reach more organizations than ever. And with the funding of the Women's Program now being at its highest level ever, the number of proposals receiving funding and the number of new organizations accessing funding, the number of firms accessing funding is growing. And the best news is, Mr. Speaker, is that the number of women expected to benefit also directly increases as well. All projects funded must support the advancement of women in Canada, and that's exactly where equality comes in. It's a complex legal concept, but it lies at the very heart of what Canadians hold dear and what Status of Women Canada is working to achieve. In recent months, the Women's Program funding has supported invaluable projects. For example, in the Atlantic region, one project will result in a strategic model for mentoring and intergenerational consultation dealing with the obstacles faced by younger and older women who live in official language minority communities. A project in Ontario, in the Ontario region, will result in the development of tools for training, mentoring, and networking programs for Aboriginal women, for immigrants, older women, and members of racial minorities who are trying to establish their own businesses based on micro skills. And in the western and northern regions, there's a project to develop a program that community groups and governments can use to support female sex trade workers during their transition to a new and better life. These initiatives are focusing on the economic security of women, and it'll mean providing meaningful results for women and girls today and in the future. They will bring about real and lasting change. They represent a rapid increase in opportunities for women and girls to participate in the life of their communities and their country, and to enjoy a life that offers financial security and the freedom that that brings. In other words, they advance equality for women who might otherwise continue to face disadvantage, discrimination, poverty, and the violence of those daily realities. And as announced in the last budget, over the next year we will develop an action plan that will advance the equality of women across Canada through the improvement of their economic and social conditions and their participation in democratic life. In addition, we will be fostering the participation of women in leadership and decision-making bodies. Women's participation in governance bodies in Canada is vital to achieving enhanced economic prosperity now and in the future. An organization's actions should reflect accurately what its goals are. With equality now included in the mandate of the Women's Program, the mandate, actions, and goals of the Women's Program once again reflect a synchronicity that is fitting and makes sense. I thank you, Mr. Speaker.
Reprise du débat.
Resuming debate, the honourable member for San Bruno, Saint-Hubert. Thank you, Mr. Speaker. I carefully listened to the member for Simcoe, the Conservative member, and I must say that what he says and what he does, well, I can say there's a big gap between what he says and what the Conservative government does. But first of all, I'd like to congratulate my colleague from Laval, my Bloc Québécois member, who explained so well the Bloc position with respect to the first hour of debate of this motion put forward by the London West member. And I'd also like to congratulate her on her motion to promote the status of women and that it be devoid of partisanship. In the days following International Women's Day, Mr. Speaker, I must say that I'm very worried to sit in this Parliament. I've been a member here for about 4 years, and I've never been called on so often to give speeches to promote the status of women. I feel, Mr. Speaker, that the carpet's sliding out from underneath our feet. I know that the Conservative government is attacking the promotion of the status of women, and we know that the funding was cut from status of women so they could no longer do promotion activities. And most recently, there was C-4083 from the Conservative member, which concerns me a great deal. This is a bill that concerns the unborn children. And under the pretext of protecting pregnant women, well, the government is giving a legal status to the fetus, and this could even result in women who abort their fetus from being sent to prison. This sets us back decades. In 2008, I find it surprising that once again I have to stand here and defend equality of men and women. I find it surprising that I have to defend women's rights and to tell men to stop wanting to legislate with respect to the bodies, with respect to women's bodies. This is schizophrenia, Mr. Speaker. I'm very concerned by this. As the Labour critic, I'd like to draw your attention to a few aspects of the block program to improve women's working conditions, particularly those women who work under federal jurisdiction. We know that in Quebec, women's rights aren't so menaced or threatened. We try and help women. There's the scab labor, which we have in Quebec, which will result in fewer lost days. And we also have preventive withdrawal for pregnant women in Quebec. This is a measure that ensures that women, I would say that if the Conservative government really wanted to protect women, this is a measure that they should think about seriously. If a woman who works in a plant, she can actually withdraw from her job temporarily if she's pregnant and get payment so that she won't have to eat into her maternity leave. That's what's done in the federal system. And all the women who work in airports or ports or in any in the telecommunications fields that work under federal law have to abide by these retrograde federal law provisions. So the Replacement Worker Act and the preventive withdrawal measures are very important measures that Quebec has taken to protect working women. I do not want to dwell to great length on this issue, but I would simply repeat my concern and with respect to this Conservative government, which is really causing women to take a huge step back.
The honourable member for Vancouver East has the floor.
Thank you very much, Mr. Speaker. And I'm very pleased to rise in the House today to support the motion from the member from London West, and I know that she's very committed to women's equality and has fought for that, so I'm pleased to be here today on behalf of the New Democratic Party to support her motion. And I'm assuming that this motion is going to get support from all members of the House, because as we know, because of the outcry that has happened across the country, because this Conservative government took out the mandate of equality from the Status of Women Canada, they've now had to kind of rethink their position, and based on the massive opposition from women's organizations across the country, the minister responsible for the status of women has finally agreed that equality will go back into the mandate for the status of women. So that's a victory, and it's a victory for all of the women's organizations and the MPs in this House who pushed back on this government and said it is completely unacceptable that equality be taken out of the Status of Women mandate. Mr. Speaker, having said that, I do want to just focus on what this issue of equality for Status of Women in Canada means. And as we just celebrated International Women's Day, I think it's important to note that while we have won equality in a legal sense, equality in a real sense in day-to-day in terms of programs and services and the wage gap, equality in terms of access to the law are still things that are being fought for. And so, for example, when we look at the wage gap that still exists in this country, the Canadian Labour Congress has produced some excellent information that is really quite shocking, that shows us that women working full-time all year still make only 70 cents for every dollar men earn. For racialized women, it's even worse. It's 64 cents. For Aboriginal women, it's 46 cents. And in fact, the pay gap, the gender pay gap in Canada is even bigger than the wage gap in the United States, and that may surprise some people. And what was most shocking to me to learn from this information is that by age 51, women's average income in this country is only 41% of the average income for 51-year-old men. I mean, that is truly appalling to know that after years of striving for women's equality, we are still so far behind. Mr. Speaker, we have further evidence of just the struggle and what needs to be done by looking at the last federal budget. And in fact, at the Status of Women Committee, the parliamentary committee, just a couple of days ago, March 13th, Kathleen Leahy, who's a professor of the Faculty of Law at Queen's University, pointed out in her presentation that the only reference to women in the budget has to do with the fact that $20 million was allotted to the Status of Women to develop an action plan for women. But when one examines this, we find out that the $20 million that's being allocated in the Conservative budget is actually $4 million less than Status of Women Canada received in the year 2002-2003. So we're not even keeping pace with the cutbacks that have happened over a number of years in terms of this department fulfilling its responsibilities for the equality of women in Canada. And if you take that number of $20 million and you apportion it out for the number of females in Canada, Professor Leahy points out that it amounts to $1.21 per woman and child in Canada. That's what women's equality is worth to this government in this budget. So that's something that we find quite outrageous and one of the reasons that we voted against the budget. Another benchmark, Mr. Speaker, is to see whether or not we are actually meeting the goal of equality for women is to, again, look at the budget and to see what's happening with some of the tax cuts. And the fact is, and again from the professor's analysis, when you look at the corporate income tax rates that have been established and the fact that the Conservative government, with the support of the Liberals, have rolled back corporate taxes, which means a loss of about $60 billion in public revenues, Professor Leahy points out that low-income individuals, most of whom are women, now pay higher income tax rates than even large corporations. So much for this gender analysis on the budget, because when you really strip it all away and you look at the numbers, we can see that the impacts of cuts, that even the tax load is disproportionately being carried by women, and in particular low-income women. The corporate income tax cuts shift the overall tax burden onto low-income individuals at the same time as they drain revenues needed to redress growing gender disparities, and that's from Professor Leahy's brief. Now, Mr. Speaker, I believe that in passing this motion today, we should see that as a step forward. But I think we should recognize that we have a huge struggle here in terms of attaining equality for all women in Canada. I'm very proud to say that in the NDP we have a very strong action plan, Fairness for Women, that covers everything from political representation to violence against women, to pay equity, to programs and services, to support for women, to childcare. I mean, these are the basics that we need to see happen. And it seems to me that when we look at the federal budget, there are some very basic choices that are made by any government when it brings in a budget. And clearly in this budget, the last budget that we saw, those choices were made in favor of people who already have very significant resources. It was a budget that clearly said we don't care about women in this country and we're leaving them behind. I have to say, like my colleague from the bloc, that I, along with other women in this House, were truly, truly dismayed that the private member's bill C-484 passed through this House a few days ago. We see this as an absolute attack on women's equality, on reproductive rights. It was a bill brought in by a Conservative backbencher. It is clearly a backdoor way of trying to unravel the decades of struggle for women's equality in this country, for reproductive rights and for choice on abortion. And I know that what the email and the messages that I got from across the country, people could not believe that we're still in this battle today to uphold those rights. So while today we're debating this motion to insert the word equality in the mandate of the Status of Women Department, Of course, that is essential. It's symbolic. It's the whole essence of what that work is all about. But while we do that, and while this motion will pass today, I have no doubt, please let us be committed and understand the reality that women in this country, and particularly low-income women, immigrant women, racialized women, Aboriginal women, women with disabilities, are struggling for their lives. They're struggling for dignity. They're struggling to have the basic necessities of life, whether it's housing, education, a living income, access to programs, to the legal system, and so on. So, Mr. Speaker, on behalf of the NDP, we're very pleased to support this motion. I want to congratulate the member for bringing it forward. It's an important motion. We want this Parliament to speak with one clear voice that women's equality must be part of the Status of Women program and mandate. It could not be otherwise. We could not let this go unchallenged. So I'm thankful to the member for bringing it forward. But let us be clear that we have many other struggles and issues to face to ensure that women's equality truly is living and breathing in this country. Thank you.
Reprise du débat, l'honorable député de
Resuming debate, the honourable member for Sudbury.
I'm very happy to be speaking today to support the motion of my colleague from London West. Since this motion was tabled, the government did hastily add the word equality back into the mandate of the Status of Women Canada. However, we're not sure it's worth very much because we really don't think the Conservatives get it.
They don't.
You know, the clock was turned back in 2006 when the government, the Conservative government, removed the word equality, and they removed it from the funding guidelines of the women's program. And after taking a quick look on the Status of Women website, one can see that this year's International Women's Day theme was Strong Women, Strong World. Status of Women Canada's website states that this theme draws in part from one of the fundamental beliefs underlying the modern women's movement, that a woman's place in society marks the level of civilization of that society. How ironic is this, given the government's actions that have hurt the advancement of women so much? For example, denying funding to groups that advocate for women's equality. Conservatives don't get it. The dismantling of the Court Challenges program. Again, they don't get it. The decimation of the Policy and Research Unit in Status of Women. Another big problem. And the closure of 12 of the 16 regional Status of Women offices across Canada. Taken collectively, these actions deny women access to services and support that would help improve their lives and those of their families. The Conservative government is in denial about the place of women in our society. They hide behind the fact that in law, women are equal to men in all aspects. No one disputes this fact, but equality under the law does not translate into equality in everyday living.
Mr. Speaker, the statistics are clear. Women are not paid as well as men. These are more likely to be victims of violence. It is undeniable that they are underrepresented at all levels of elected government, whether it be at the local, provincial, or federal levels. They are the victims of poverty in our society, and this Conservative government continues to ignore the status of women in Canada.
Has a role to play in ensuring that women are full participants in all aspects of our society, economic, social, political, and cultural. This is why the Liberal government in the 1970s established Status of Women Canada, to help women overcome the challenges and barriers they face in their lives. However, in September 2006, the Conservative government cut $5 million from the Status of Women Canada in what was called, at the time, an effective savings exercise, claiming that these funds were an inefficient use of taxpayers' dollars. I remember at the time hearing the minister responsible actually claim of what use was this money. After all, it was just going to pay for phones and things like that. Showing a very big lack of understanding. As a result of these cuts, 61 of 131 staff positions were eliminated, and 12 of the 16 regional offices that provided assistance to local women's organizations were closed. And the Policy Research Fund, a highly successful program that funded independent, high-quality research about policy affecting women's equality, was disbanded. And you know, what's a little bit sad to realize is that while they've been cutting research and funding for advocacy for women and for women's groups, they certainly haven't cut funding for advocacy and research for national defense. National defense directly funds all kinds of advocacy, all kinds of research in support of national defense. And I'm not saying that's wrong, but why would you cut the same programs that help women who really need the help? And it has to be because the Conservatives don't get it. At the same time as the cuts, the government announced new terms and conditions for the women's program, which is the main vehicle used to fund projects. These changes included removing the word equality as one of the goals of the women's program. Well, we do know that they've put the word back now, but, I mean, it's just a cosmetic thing, I believe. Denying funding to any women's organization that undertakes advocacy activities. Restricting capacity building in organizations, except under very special and narrow circumstances. Opening up the women's program to the for-profit organizations. Now, in March 2007, the government claimed this measure was never meant to be a cutback. That's the cutting back of the $5 million. Despite having said so earlier, it announced that the $5 million savings would be transferred to the women's program, which was being divided into two components, the Women's Community Fund and the Women's Partnership Fund. And the Women's Community Fund will support projects at the local, regional, national level, and the newly created Women's Partnership Fund is, they say, an enhancement to the existing grant program. However, since the introduction of the new terms and conditions put in place by the Conservative government, the women's program no longer supports projects that seek to promote women's equality. In other words, there is money available, but not to equality-seeking organizations which do advocacy work. But remember, they are still funding for-profit groups. And, you know, it's a little bit sad to see that happening because for-profit groups generally don't need the money. But the other groups are always begging for anything. They're not going to get any funding. Le budget fédéral.
The federal budget of March 2007 allocated $20 million in new funding for Status of Women Canada over 2 years. It is not clear how this money will be distributed. Perhaps we should ask the government to be more accountable for this. Although the Conservative government protests this, it has done irreparable damage to Status of Women by not allowing Canadian women to participate on an equal footing on all recommendations or initiatives that affect any aspects of our society.
You know, why is this happening? Because the Conservatives just don't get it. And maybe it's because there aren't enough women as part of their caucus. I'm sure the women understand, but they're not strong enough to influence the thinking of the Conservative caucus. Women work differently than men. They work collegially. They test ideas to make sure that they work, that they're sound and valid. Status of Women's offices, for example, were places where women could meet and work together to advance their cause. It's a shame that that vehicle has been shut down for many, many women. I would ask, Mr. Speaker, that the government follow the example set out by the Liberal Women's Caucus, who came out with a huge study, 2 of them, on a number of policies which we went across the country asking for advice and opinions. We didn't formulate that by ourselves. We did it collegially with women across the country. I ask all members to please support this motion for true equality, but not just with words, with real actions. Thank you, Mr. Speaker.
Resuming debate, reprise du débat. I recognize the honourable member for London West for her right of reply.
Thank you very much, Mr. Speaker. And I do thank every party in this House for participating in this debate. I think it's an important discussion that this country needed. I was very affected, and so were the women in this country, and the men who were supportive of those women when back in 2006 the mandate of the status of women did change, and that word equality was removed. And it didn't just go back because the Conservative Party felt differently now. They felt differently about equality. I want to remind this House, but I've already had my opportunity in the first hour debate to do my full speech, but when I tabled this motion, it was because the equality provision wasn't there. And in fact, I attended the meeting of the Standing Committee on Status of Women on February 5th of 2008, when the Minister gave her opening remarks, of which I have a copy. And again, there was no discussion. There certainly was no press announcement of change, no announcement of this happy news. I want to say that on that date, the face page of the website of the Status of Women had changed, but my first hour of debate was February 7th. On the morning of February 7th, I came to this Parliament and we opened the computer to check whether anything had really changed. And on the morning of February 7th, if you went into the women's program, I want to get the exact words here. The program mandate read, the mandate of the women's program is to facilitate women's participation in Canadian society by addressing their economic, social and cultural situation through Canadian organizations. It goes on further, but no mention of the word equality. I was to speak a few hours later. Just before I spoke, a couple of hours before I spoke, you go into the computer and the program mandate miraculously is the newly revised mandate of the women's program is to advance the equality of women across Canada through the improvement of their economic and social conditions and their participation in democratic life. Well, there we have it, Mr. Speaker. There's been a change, but real change has to be followed through with real guidelines, real programs, real financing, and advocacy for equality is an important part. So I'm saying to this government, they've put the word back in now. Thankfully, I don't think it would have happened without this motion. I don't think it would have happened without the voices from every party of women and women's organizations on the ground for fighting for this. But to make it real, to make it worthwhile, to make it something that actually changes the status quo, advocacy and research for equality is important. And I hope they don't demean this, because it's important enough when we have lobbying from the military establishment. They get dollars to do that. They can't say that's not important for them, and I don't disagree with that. But I also think that advocacy for equality is vital if we're going to do more than just help people manage with status quo. If you want real change in this company, the women in these halls, in these chambers, out there on the ground, working in organizations, not for profit, they need to know that a government is going to stand behind them, that they really want equality of women to be the goal. And the women's program is not the only thing. It certainly isn't the only thing, but it's one thing that can help. And if you've now put the word equality there, follow through with the advocacy so we can have a better life for women here in Canada. Thank you very much to all of you who've spoken on this. I appreciate your work and I appreciate the support, but it's not for me. It's the support for the women of this country.
Hear, hear. Over here.
La période réservée au débat est...
Period for debate has expired. Therefore, the question is as follows.
Ms. Mina moved that the House call on the government to reinstate women's equality as goals of the women's programme at Status of Women Canada.
Is it the pleasure of the House to adopt the motion?
La motion est donc...
The motion is therefore carried. It seems that it's unanimous.
It being 2:07, the House stands adjourned until Monday, March 31st, 2008 at 11 a.m., pursuant to Standing Orders 28.2 and 24.1.
Did you make that November 1st? Have a great Easter, Mr. Speaker. Hey, happy Easter.
It's our people.
What the deuce is all the commotion?